I'm Floyd B. McKissick Jr., a commissioner with the North Carolina Utilities Commission, and I'll be presiding over this hearing. With me this afternoon are Commissioners Kimberly W. Duffley and Jeffrey A. Hughes. I now call for hearing docket numbers W-933 sub 12 and W-1328 sub 0, which is the joint application by Redbird Utility Operating Company, LLC, doing business as Redbird Water, hereinafter referred to as times as Redbird, or the applicant, and Etowah. We'll get that name at a point where everybody, we know what we're all talking about, notwithstanding the pronunciation. Sewer company, hereinafter referred to its times as Etowah, for transfer of public utility franchise and for approval of rates. Before we proceed further, and as is required by the State Government Ethics Acts, I remind members of the Commission of our duty to avoid conflicts of interest and inquire at this time as to whether any commissioner has any known conflicts of interest with respect to these dockets. Let the record reflect that I have no such conflict, and no such conflicts have been identified by the other commissioners. On October 8th, 2020, Redbird and Etowah filed with the commission an application for authority to transfer the wastewater utility system and public utility franchise serving the Etowah community in Henderson County, North Carolina, from Etowah to Redbird, and for approval of rates. Redbird filed with the commission supplemental and additional materials in support of the application on October 19th and 22nd, 2020. The transfer application requested the commission approve the transfer of the wastewater system assets, approve the transfer of the public utility franchise from Etowah to Redbird, and approve wastewater rates as currently approved. The present wastewater utility rates for the Etowah community were approved in dockets W-933 sub 10, effective as of January 1st, 2016. On December 22nd, 2020, the public staff filed a deficiency letter outlining information that was needed to complete the application. On May 14th, 2021, October 7th, 2021, February 15th, 2022, August 18th, 2022, and August 23rd, 2022, Redbird filed supplemental material to address deficiencies identified by the public staff. On June 14th, 2023, Redbird filed a letter indicating that it considered the application to be complete. On July 25th, 2023, the public staff filed a second deficiency letter outlining additional updated information needed to complete the application and recommended that the commission determine that the application was incomplete. On July 28th, 2023, the commission issued an order finding application incomplete. On August 22nd, 2023, the public staff filed a letter with the commission indicating that this docket now includes all of the information required for a complete application. On September 14th, 2023, the commission issued an order finding application complete and requiring the public staff to provide specific application data. On September 21st, 2023, the public staff provided information requested in the commission's September 14th, 2023 order and notified the commission that additional information would be provided upon Redbird's response to data request number 9. On September 26, 2023, the commission issued an order scheduling hearings, establishing discovery guidelines, and requiring customer notice. The order scheduled a public witness hearing, which was held on November 1st, 2023 in Hendersonville, North Carolina, as well as an expert witness hearing to be held at this time and place for the purpose of receiving expert witness testimony. This hearing will continue as necessary until its conclusion. On October 4th, 2023, the commission issued an order approving Redbird's proposed customer notice. On October 10th, 2023, Redbird filed the confidential and public redacted direct testimony and exhibits of Josiah Cox, consisting of 32 pages and 4 exhibits. On October 19th, 2023, the public staff filed a motion to revise the order scheduling discovery guidelines, filing dates for pre-filed testimony and witness lists, and requiring reports. On October 20th, 2023, the Commission issued an order amending discovery guidelines and filing dates for pre-filed testimony. On October 27th, 2023, the public staff filed the direct testimony of John R. Hinton, consisting of 5 pages, 1 appendix, and 1 exhibit. The confidential and public redacted testimony of D. Michael Franklin, consisting of 25 pages and 1 appendix, and the confidential and public redacted direct testimony and exhibits of Lynn Fiesel, consisting of 7 pages, 1 appendix, and 4 exhibits. The intervention and participation of the public staff in this proceeding is recognized pursuant to North Carolina General Statute 62-15, subsection D, and Commission Rule R01-19, subsection E. On November 13th, 2023, Redbird filed rebuttal testimony with Josiah Cox, consisting of 28 pages and 2 exhibits. Rebuttal testimony of Brent G. Theis, consisting of 10 pages and 1 exhibit, and rebuttal testimony of James A. Breckmeyer, consisting of 12 pages and no exhibits. On November 14th, 2023, Redbird filed corrected, confidential, and redacted public testimony of Brent G. Theis, consisting of 10 pages and 1 exhibit. That brings us to today. We are ready to begin. I call upon counsel for the parties to announce their appearances for the record, beginning with the applicant.
Good afternoon, Commissioners. Mindy McGrath with the law firm of Troutman Pepper. I'm here today on behalf of Redbird, and I'm here with my colleague, Molly Jagannathan. Thank you.
Thank you. Recognize the public staff.
Good afternoon, Commissioners. Davian Newell of the public staff representing the using and consuming public, and I'm joined at council's table by James Bernier Jr. and Gene Holt.
Thank you. Are there any preliminaries that we need to address?
Yes, Commissioner.
Yep.
So first, the public staff would like to move to dismiss witness John Hinton. Unless the commission has questions of him, the filing party, the applicant has no time reserved for cross-examination. So we will anticipate unless the commission has questions.
And I will recognize the applicant for a position.
No objection.
And I'll look to my fellow commissioners to see if they have any objections. Without objection, your motion is allowed.
And secondly, the parties are asking leave, or the public staff is asking leave to make a brief opening statement. And the applicant has asked for an opportunity to also make a statement.
Duly noted. It's my understanding the applicant concurs with what has been stated on the record at this time.
Yes, that's correct. We would just like an opportunity to respond.
Okay, we'll go ahead and recognize you now for your opening statement.
So presiding Commissioner McKissick, may it please the commission, you will hear today that the public staff believes that the company has the technical, managerial, and financial capabilities to operate the Etowah system. But those capabilities only play a part in the commission's determination that the proposed transfer is in the public interest. The public staff does not oppose the transfer of the Etowah wastewater system to Redbird, but determinations and limiting conditions are needed to protect the using and consuming public. In this docket, Redbird has paid an exorbitant and unsupported price for the Etowah system and intends to pass on that price through rate base to its customers in the next rate case. The threshold for whether Redbird should be allowed cost recovery of an acquisition adjustment has been set appropriately high by the decisions of the commission and judges over the decades because it is the exception and not the rule. To further accentuate the problem, Redbird wants to push off to a future rate case the full recovery it seeks of the large sums of expenses and its due diligence costs. It is the public staff's position that an increased level of scrutiny applies when a company asks customers to share costs that other utilities have historically foregone. The public staff is opposed to allowing Redbird to pass what we contend to be its cost of doing business onto ratepayers. Further, the ratepayers deserve transparency in this process. As you've seen and heard from customers, they want to know future potential rate impacts. However, Redbird has fought to avoid forecasting rates that may be likely in the next 3 years. Even though we know that the amounts that have been spent so far, and we know what we expected expenditures in the coming years. Redbird seeks to constrain the scope of the Commission's review of the transfer and its claim that the newly passed statute requires a procedure that diverges from the regulatory process in North Carolina, which requires the Commission to take all factors in considering whether the transfer is in the public interest, including any acquisition adjustment and due diligence costs. The public staff disagrees and asks the Commission to consider all appropriate facts and circumstances in its consideration of whether the transaction is in the public interest. The public staff urges that approving the transfer without deciding the issues of purchase acquisition adjustments and due diligence is counter to the best interests of the public and burdens the public staff and the Commission with administrative inefficiencies. On its face, it seems the Commission has a simple decision to make: a transfer at existing rates to a professional utility whose business model is to acquire and recapitalize failing systems. However, there's more than meets the eye. This proposed transfer presents unprecedented due diligence costs, a large acquisition adjustment, and a multi-layered corporate structure. Despite its request, the company has thwarted the public staff's attempt to gain information by providing invoices with entire pages redacted, providing evasive responses regarding investors and its corporate structure, and not providing support for its overinflated net book value. The ratepayers of North Carolina deserve transparency, clarity, and quality service at just and reasonable rates. The public staff endeavors in this proceeding to make the customers the heart of this, not a company who seeks to bolster its profits beyond what is allowable by the Commission at the expense of customers. Thank you.
Thank you. I'll now recognize Attorney McGrath on behalf of the applicant.
Thank you, Commissioners. Redbird obviously takes a very different position than the characterizations that public staff just put forward. We would contend that the issues before the Commission today are not contested. Public staff, as they acknowledged, have testified that they do not oppose the transfer application. They've also provided testimony that Redbird has the technical, managerial, and financial capabilities necessary to provide public utility service. There's also no dispute that Redbird intends to continue charging pre-existing rates to Etowah's customers, rates that this Commission has found to be just and reasonable. Everything that public staff seems to be focusing on, acquisition adjustment, due diligence costs, effect to rate base. These are issues that are most properly examined in the context of a rate case hearing. That is not why we are here today. Redbird is not requesting that the Commission rule on rate base or an acquisition adjustment or the appropriate amount of due diligence costs, if any, to include. We think it's premature for public staff to prejudge or speculate what those costs may be. The statute governing the transfer of public utilities specifies 3 findings that this Commission must make: whether or not the transfer is in the public interest, whether or not the transfer will adversely affect service to the public under any existing franchise, and whether the person acquiring the franchise has the managerial, financial, and technical capabilities, which is undisputed. So again, at the time of a rate case is when issues that seem to be troubling to public staff can be examined, when all of the evidence is before this Commission and the public staff and any interested party who so wishes to intervene. And we would ask that the Commission at that time rule on those matters, specifically as to whether or not an acquisition adjustment is in the public interest or the amount of due diligence costs that should be included in rate base. And so based on those considerations, we would respectfully ask that the commission rule in Redbird's favor and approve the transfer application for the Etowah facilities, which is what is currently pending before the commission today. And I would just pause and ask if my colleague has any additional comments to make.
No, nothing.
Okay, thank you.
If there are no additional comments, we're ready to begin. You can call your first witness.
Thank you, Commissioner. At this time, Redbird would like to call Josiah Cox to the stand.
Not yet. Apologize.
Oh, that's okay. If you could place your left hand on the Bible and raise your right hand. Do you solemnly swear that the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Good afternoon, Mr. Cox. Can you please state your name and your business address for the record?
My name is Josiah Cox. It's 1630 DePere Road, Suite 140, St. Louis, Missouri, 63131.
And by whom are you employed and in what capacity?
So I'm the president of Redbird Utilities, but I'm also the president and founder of Central States Water Resources.
Mr. Cox, on October 10th, 2023, did you prepare and cause to be pre-filed in this docket direct testimony consisting of 32 pages and 4 exhibits?
I did.
And does your testimony contain any confidential information?
It does.
And do you have any corrections you need to make to your pre-filed testimony?
I do not.
And if I were to ask you the same questions that are set forth in your testimony while you are under oath here today, would your answers be the same?
Yes.
Commissioner McKissick, at this time, I would like to request that the pre-filed direct testimony of Mr. Cox be copied into the record as if given orally from the stand, and that his exhibits 1 through 4 be identified as marked when they were pre-filed.
The pre-filed direct testimony of Josiah Cox will be received into evidence and treated as if giving orally from the witness stand. The attached exhibits, and appeared to be 4 exhibits, as well as 32 pages of testimony, will become a part of the record as it was pre-filed and as it's been marked and identified.
Thank you. Commissioner McKissick, Mr. Cox is now available for cross-examination and questions from the commission. I would just note that Mr. Cox will be back on rebuttal as part of a panel. Thank you.
We'll recognize the public staff.
Thank you, Commissioner. All right, good afternoon, Mr. Cox.
Good afternoon.
So I have a few questions for you, and hopefully they're not overly onerous.
You might want to move the microphone a little closer to you, or speak a little louder, perhaps.
Can you hear me now?
Yes, ma'am.
So on page 5, line 21 of your direct testimony, you contend that the Etowah system is either distressed, troubled, or requires an infusion of capital investment that the current owners are either unable or unwilling to provide. Can you tell us what your definition of a troubled system is and what criteria you use to determine that a system is troubled?
Yeah, absolutely. In fact, in my rebuttal testimony, I go through great detail where we talk about other states and their policies and how they determine whether or not a system is troubled or in distress. And I would use those words synonymously, actually. I go into detail here, think about the Etowah system. So in the Etowah system, in the last 5 years, they've only had 1 quarter where they've not had non-compliance, where they've had compliance. So they've been out of compliance for almost the entirety of the last 5 years. Since the time we signed this contract in 2020 till today, there have been 11 notices of violation and many more instances of non-compliance. So in addition to that, you can tell over the last 5 years there have been no additions to plant and service, basically. And the utility has lost money for almost every single year in the last 5 years. And especially, there's some contention, the accounting currently about tap-on fees, whether or not those are contributions in aid capital, or whether or not those are actually just cash payments. And since they're recorded in the annual reports as cash payments, the actual operating loss on the system is significantly higher than even stated in the annual report. In addition to that, the owners have themselves said, hey, we're not supposed to be in the utility business. We don't have the capital or the expertise to really upgrade or run this system, which is evidenced by, earlier this year, I got a call from the Department of Environmental Quality. They had a lift station that was overflowing for, I think, 2 weeks. And, they recorded a sanitary sewer overflow of 600 gallons. That was a single day's overflow. It's actually much more than that. If you think that the lift station had been overflowing for a much longer period. And, the thing for us as a company, when we see sanitary sewer overflows, consistent violations of permit level limits, especially stuff like fecal coliform, which is an indication of human health pathogens being, let into surrounding water bodies. Really what you're doing is there's 20,000 residents below this wastewater treatment plant. You're releasing potentially, human health impacting, pathogens, this kind of stuff that causes disease. So those are all very clear indications, plus the fact these sellers do not have a clear, they don't have a clear succession plan. We've done all the work to they didn't have existing site maps, line maps, existing plant records. All those things are indications of a troubled, distressed utility.
And what is the significance of your determination that the system is distressed or troubled as it relates to this proceeding? And the follow-up to that is, can you point to an order that allows an acquisition adjustment on that basis?
So repeat the first question, if you don't mind, ma'am.
So the first question is, what is the significance of the determination or your determination that the system is distressed or troubled?
The significance is that these owners pose a human health risk and a collapse of service risk to the customers is the big point. We see this, thanks. So we're the largest owner of individual domestic wastewater treatment plants in the United States. And we've come to states with the highest amount of fragmentation, so most amount of small systems, and the highest amount of non-compliance. And North Carolina fits in both those categories. And these are the type of systems, the Etowah system is indicative of systems we own hundreds of across the country. And really, these are the people that are putting human health at risk that really need out of the business. And so that distress determination, which in fact, I think North Carolina on the water side has some specific language, what they consider distress, and a roadmap that I have in my testimony. And, this system falls right down the median for a system that needs to be professionally managed, operated, and invested in over a long period of time.
And can you tell me sort of what is the significance of that as it relates to a potential acquisition adjustment?
So we think that these owners need out of the business. And, this is interesting. We see this in the regulatory world all over the country. So, for example, the Etowah owners, they're paying themselves a salary. They have company trucks. There's economic value coming out of this system, even though they've had, 4.5 years of non-compliance. And really what we see is we're here at the intersection of where if you're an environmental regulator, every dollar of fine money you take out of an owner is another dollar that doesn't go into plant, that doesn't go into lines, right? And then, the economic regulators are not pressing for these people to get rate cases. In fact, Etowah's proven they really have the technical managerial ability to do a rate case. The last rate case, I believe, was a rate case on a margin of expenses rather than rate base, which is interesting that we're arguing about rate base right now because I don't think that's been set for, close to 20 years. So the reason why that matters is these people have an economic benefit out of this system. They have to be paid for it, and they're distressed. So there needs to be some consideration that it's better for the public for them to be taken out of the business.
Right, but what does that have to do with your company getting the acquisition adjustment?
Because the only price that they would sell for is the price that we negotiated to, and they need out of the business.
So I guess, I'll just bear with me. Because you said the only price that they will accept is what, or that the price you paid is the price that, the only price they'd accept to get out of the business.
It's the lowest negotiated price we could get, correct?
So if I tell you that you're in the business of selling pens, for instance, and I say, I'm willing to sell you this pen for $1,000, what would be your response?
That pen's not dumping human pathogens through a receiving water body that has 20,000 people downstream.
But it's the only price that I'm willing to accept.
20,000 people are in danger because of that pen.
Yeah, a pen, 20,000 people are in danger. What am I doing with the pen? Or what are you proposing to do with this pen?
Fix it so all those people are not in danger anymore.
Uh-huh. But I think we can tell from this exercise, right? Just because that is the only price I'm willing to accept for the pen does not mean that it's a reasonable purchase price. Wouldn't you agree?
No, because the pen's causing you $80,000 of revenue a year.
So because it's the only price I will accept, you think it's reasonable and prudent to pay that amount for this pen?
I think it's reasonable and prudent to knock a person out that's putting 20,000 people in danger who's pulling an income out as residual value. Yes.
So your company has been acquiring numerous systems in North Carolina and in various other jurisdictions. And you've made promises to improve those systems, have you not?
Yes.
Have you been upholding your portion of the deal regarding those promises?
Yes. We've never violated agreement on consent or agreed order in company history.
Okay. So is the wastewater treatment plant at Pine Knolls Town 2 still in service?
It is.
And is the septic system servicing Pine Knolls 1 and 3 still in service?
I don't know the answer to that question. I know we put emergency FEMA system in there to process the waste because the septic system had failed.
It's subject to check. Would you agree or would you accept that it is still in service?
I don't know the answer to that.
Did you represent to this commission that the planned improvements would result in these being taken out of service and decommissioned? And I'm referring you back to your response in the Pine Knolls 2 question.
So I think you're confusing the issue because the septic tanks now run into a wastewater treatment plant. So they're no longer acting as a septic field.
So I'm referring to Pine Knolls Town 2. Because you indicated to in response to my question that that wastewater treatment plant was still in service.
I believe, ma'am, that's running into it's running into a extended aeration plant after being collected in the septic.
Did you represent to this commission that the planned improvements would result in these being taken out of service and decommissioned?
I know we represented, we would make sure that the waste is being treated. It's no longer being, because that was a failed septic leach field that we put into a discharging treatment plant.
And what about the new plant that you promised?
We installed a plant on site. I mean, it was one of the first things we did in that system. We had to bring an emergency plan in because the septic field had failed completely. In fact, we have another application that have not gotten sufficiency yet because of the detailed engineering work that your staff would like. We're trying to do a centralized plant in that whole area. That'll be the Sugarloaf system.
So you installed a temporary plant?
It's a actual treatment plant that we installed, an interim plant.
Temporary plant.
I wouldn't call it a temporary plant. It's meeting limits.
So it's meeting limits, but is it the new plant that you promised?
Yep.
Was that the intention of the new plant?
We actually looking at doing a larger plant now in that area.
Yes. Thank you for finally getting to the answer. So clearly, as we're seeing demonstrated here, you talk a big game, but how do we have any assurances that your company is actually going to fulfill what you've promised us?
Ma'am, we've turned around 180 plants. We're on track by the end of next year to turn more plants around, wastewater treatment plants, than any company since the passage of the Clean Water Act. There's no one better at turning around these small plants than our company.
So is it your testimony here today that all those plant systems or those systems are connected to the temporary plant?
I don't know what you're talking about. What are you saying? Which system? Can you clarify for me?
In Pine Knoll Towns?
Ma'am, I don't remember.
And Ocean Terrace?
I don't remember. Wasn't prepared to testify on that today.
Well, are you prepared to acknowledge that you haven't in fact completed all the work that you've promised in those systems?
I don't have those problems. I don't have those in front of me, ma'am.
I'll move on. So we've already talked a little bit about sort of the prudent purchase price, right? That just because that's the amount that they were willing to accept, just as if I offered to sell you a pen for $1,000 and that's the lowest amount I'll accept, that you think that is prudent.
Again, your pen's not putting 20,000 people in danger and throwing off $80,000 a year in cash to the owner. So I think that analogy falls apart.
So let's talk about this a little bit further. You testified in your direct testimony, page 26, slides 9 to 11, and I quote, "Price to be paid for the Etowah system was negotiated at arm's length between totally unrelated parties. Etowah would not sell a system to us for any less. Purchase price we agreed to pay is prudent." Correct?
Correct. I see that in my testimony.
Yes. And you've discussed publicly a database of water and wastewater systems that CSWR has compiled. Is that also correct?
Correct.
And did you identify the Etowah system using that database?
That's why we came to North Carolina.
And did Redbird initiate contact with Etowah?
Yes, we did.
And what was the initial offer to Etowah?
Normally we start with $1.
Excuse me, I'm sorry. I think we're getting into some confidential, wading into, the purchase price has been marked as confidential, so I just want to flag for the commission's consideration.
If we're moving into this confidential round, we need to go into closed session.
That's not necessary at this time, Commissioner. I would just note, the public staff asked in DR 14, question 7, what was the amount of the purchase price? And would you agree that the response to that discovery request was that Redbird has no information responsive to this request?
I don't, can you say it all over again?
In response to that question,
To what question?
the amount and date of the initial purchase price offer made for the Etowah system.
Okay.
That Redbird's response was Redbird has no information responsive to this request.
What's your question, ma'am?
Was that your response?
I think that was in the DR, yes.
So if you have no information regarding you're saying that you negotiated and that was the lowest price, but you've provided no information to the public staff in that regard. that correct?
That is the answer to the DR, correct?
And you agreed to the purchase price on August 23rd, 2019.
That sounds accurate.
And has the purchase price changed since that time?
Not that I'm aware of.
Are you familiar with the concept of depreciation?
I am.
So do we agree that the plant has depreciated since that time?
It depends on what other investments were made after that and whether or not those tap-on fees were capital or were they cash.
You indicated in your testimony previously in this proceeding that the company is distressed, that there no improvements in plant, so much so that you're willing to pay any amount of money that they're asking for in its purchase price. But you don't believe that the plant or the assets have depreciated.
I'm not saying that. I mean, in fact, I would say, to your original question, these sellers are mom and pop outfits who are scared of regulation. They have not been able to file rate cases. They have a failing plan. So, some of these people they're not sophisticated. They're not big email people. So this is a very relational sale. So our business developers are trying to get the lowest possible price.
And so do you think by virtue of being a mom and pop operation, they should get whatever price they ask for?
No, but they understand that they're pulling money out of it and it has economic residual value.
And do you recognize that the plans would continue to depreciate anyway?
So what was the question?
Because you indicated that you didn't necessarily believe that the plans would depreciate.
No, plants always depreciate.
Yes. And I guess a follow-up to that is, given the accumulated depreciation, wouldn't the net value be reduced?
When we signed this contract in 2019, I never thought it would be 2023, and we're still going through the acquisition case. So I don't think it was ever contemplated inside the sales contract.
So I'm going to take that to mean that you haven't made any attempts to renegotiate the purchase price.
It's actually the opposite. It's been very hard to keep the contract alive because the sellers are so frustrated with how long the process has taken.
Commissioner, I am going into a line of questioning regarding a confidential filing to the joint application.
Okay, well, let's see who is in the hearing room at this time that would need to leave so that we can go into confidential session. I'll depend upon the attorneys to identify those that are unnecessary. Okay. Let the record reflect that we're now going into confidential session to deal with confidential exhibits that have been pre-filed with the commission. You may proceed with your questioning. Before I do that, 1 second, I did not provide the applicant an opportunity if they had any questions at this time. For the confidential provision.
Oh, no, Commissioner. No
Okay.
questions. Thank
All
you.
right.
So presiding Commissioner McKissick, at this time, I would like to introduce a cross-examination exhibit. This is an invoice for 21 Design Group provided in the company's response to the public staff data request. And I'd like to have it marked as Public Staff Cox Direct Testimony Examination Exhibit 1.
Okay. Do you have copies of that
I
to be
do.
distributed? Thank you.
Thank you, Matt. Thank you.
What we will do is identify this as Public Staff Cox Direct Cross Exhibit 1 for the record. And I don't see any objections at this time.
No objection.
Okay, you may proceed.
So according to your testimony on page 19, lines 15 to 17, you and CSWR personnel are responsible for providing services and or oversight to Redbird's operation, correct?
Correct.
And does that include reviewing contractor invoices prior to payment?
Yes.
So I'd like you to take a look at the invoice for 21 Design. And can you tell from the invoice what work they've completed?
You mean from the blacked out version? Can I tell what they've done? I cannot. I know what they do in general.
So you would agree that you can't tell from this invoice what work they did. The public staff would not be able to tell from these invoices what work they did.
We don't approve redacted invoices.
Okay. So I'm gonna point you to the invoice that is listed as number 10976.
I see it.
So if you look at the bill to portion, it doesn't look that this invoice is related to the Etowah system, is it?
It does not appear to be.
So we've got blacked out redacted invoices and figures and charges that are not related to Etowah.
Seems like this was a mistake.
And Commissioner McKissick, at this time, I would like to introduce a second cross-examination exhibit. And this is the invoice for Burns, Day, and Presnell. And I'd like to have that be marked as Cox's cross-examination 2.
Okay, Public Staff Cost Examination 2. Are there any objections?
No objection.
Okay, you may proceed. It's allowed.
If you look at the description listed on the first page, dated March 29, 2022. And if you can read the description of the work,
Which invoice are you on, ma'am?
I'm looking at the invoice for Burns Day in Presnell.
Which invoice number?
Oh, the invoice number is 72562.
I have it.
And then the date, March 29, 2022.
I see that.
Okay. And can you read that description?
Email to, an email from T. Thomas, email to D. Drews regarding meeting with Tribute, email from and email to Drews, email to client personnel.
And is that related to the Etowah system?
I have no idea.
And if you also look at invoice number 72943 and 73126. There's work performed on June 29th, June 28th, and dates in July respectively. And can you look at the description of work listed on those items?
I see it.
And are those related to the Etowah system?
I have no idea.
So you'll see from the description, it references the Tribute RV development plans and the Tribute RV park development plans. Do you know what those are in reference to?
I do not.
So have you reviewed these invoices?
I don't approve legal invoices.
So you're responsible for oversight and due diligence, but you don't approve the invoices, payments of which you're authorizing and ultimately seeking to transfer to cost payers?
I'm the CEO of the 11th largest investor-owned water and wastewater utility company in the United States. I don't approve every legal invoice.
Who does approve these invoices?
That would be our general counsel.
Okay, and then do you have any oversight of the people who work under you?
Yes, I do.
Exactly. So I'm going to turn now to the McGill invoices we received. And at this time, Commissioner, I would like to introduce the McGill invoice as a cross exhibit.
Okay, we will introduce that as Public Staff Cox Direct Cross-Examination Exhibit 3. The preceding one would have been Public Staff Cox Direct Cross-Examination 2. You've had a chance to review that? Do you have any objections?
No objections.
Okay. Exhibit introductions allowed. You may proceed.
Thank you, Commissioner. So, Mr. Cox, if you can turn to invoice number, let's see, 12320. So it's the invoice that's dated August 15, 2021.
They're both sides are dated August 15th.
So the invoice number ending in 12320.
I see it.
Can you, it says on here, it's an engineering permitting. Do you see that?
I do.
And can you describe for us what engineering permitting was required for a system that you have yet to purchase?
That $9,200 fee matches the preliminary engineering report that was done by them.
So it says engineering permitting.
It's a engineering firm. Their building codes don't match up to what they do necessarily.
Okay. So you don't actually know what that is in reference to.
It's,
Objection, that's not what he testified to.
Sure.
That's sustained. You might want to re-ask the question.
This engineering permitting that's listed on the invoice, you don't know what it's referring to.
I assume it's for the preliminary engineering work they did.
Okay. So is this the level of oversight that is used to determine the expenditures and ultimately what customers will be liable for paying?
Absolutely not. We have an engineering director who goes through all those and a vice president who goes through those as well.
But all we know from this proceeding is that all of the invoices so far that I've referenced, you've identified mistakes. You've identified invoices that don't have anything to do with Etowah. And you've identified invoices with work that you have no idea what's being done.
I just-
Objection, again, I would say that that's a mischaracterization of Mr. Cox's testimony thus far.
Would you like to be heard?
Your Commissioner, I don't believe it's a mischaracterization. He doesn't know what work is being done. He specifically said that it didn't refer to the Etowah system. And he also said that he believes that there were mistakes. I'm not sure how that's a mischaracterization of the testimony that he's giving on the stand.
Objections overruled.
And just 1 second, Commissioner, while I have a few other exhibits to introduce, and they are a sampling of invoices that the public staff has received.
Do you want to introduce them individually or as a group?
I will introduce them as a group. So for
Let's-
Breckmeyer, Lemoyne, Black, Slaughter,
Commissioner McKissick, if I may,
Sure.
you know,
It may be more challenging doing it as a group as opposed to individually.
well, maybe I'll frame it as an objection. I would just reiterate for this commission's consideration that Redbird is not seeking a ruling on due diligence costs or proposing to recover any due diligence costs as part of this transfer proceeding. And so I've, allowed the handful of exhibits to be admitted thus far, but at some point in time, I just question the relevance of this line of questioning and the introduction of multiple exhibits consisting of due diligence invoices.
Understood. I'm going to give her a little latitude to see where she's going with this. Since the due diligence and the amount of the due diligence cost and issues are before us as a part of the issues for consideration by the commission.
Thank you.
Now, I assume you want us to introduce these documents collectively as a group, which would be public staff cross-direct examination exhibits number 4. And what I see including among them is a invoice -75-041 dated August 8th, 2022 from Beckmeyer Law. An additional statement or invoice dated August 15th, 2020. Statement number 208686 from Black Slaughter Law, as well as what appears to be an invoice dated September 7th, 2020, statement number 228780 from Law Firm of Carolinas. I'm just realizing you have some things printed on the back of these, don't you? They're not just one-sided exhibits. And as well as a document from Val Bridge Property Advisors. Invoice dated September 27th, 2019. Do I need to identify what's on the back side of these as well? No. All right. So that is what we have before us. Would you like to be heard?
Commissioner McKissick, I would just ask, so are we admitting these as a composite exhibit or individually? And were these provided in response or with the application or in response to a data response or request, I should say?
If you could clarify what the source of these
Yes.
invoices are so that it's clear for the record.
Sure. These invoices were provided in response to a data request.
And could you specify which one?
I think that's appropriate.
Sure. One moment, Commissioner. Data request 9.
In request number 9. Are there any objections?
And no objections.
Without objection, introduction of the exhibit is allowed. In the future, if you could put a clip on these things so that we can keep them together.
Sure, certainly. So, Mr. Cox, I provided a sampling of invoices that have been provided to the public staff. And if you can take a look at these invoices, can you tell me anything regarding the work that was done?
I can't see the redaction.
And is this generally indicative of the level of oversight that you've provided in this proceeding or regarding the work that has been done?
Is what?
Because looking at these invoices, you can't tell what's been done, correct?
The redacted version? No, I cannot.
And I guess a follow-up to that is, if you can't tell, how would the public staff
It said legal invoices redacted. I agree.
Objection. Again, we are not seeking recovery or inclusion of due diligence costs as part of this proceeding.
Yes, Commissioner. So the public staff has taken the position that the due diligence costs, acquisition adjustments are all information that the commission gets to decide in this proceeding. All of these considerations impact future rates. They impact costs that are going to be absorbed by ratepayers. And I think it's important that we discuss it here. And we make those determinations as it is the commission's authority and purview to do, and has long-standing been the practice of this commission.
Could you restate your question?
Sure. Is this indicative of the level of oversight you have provided in regards to these costs?
No. Yeah, in fact, in some future rate proceeding, we would have to produce more detailed documentation that shows how the title defects, the lack of easements, the lack of property information, all impacts our ability to provide service. And that's what we would do to future rate proceeding. So this has nothing to do with our level of oversight.
But in this proceeding, the public staff asked for this documentation, and this is what was provided. What would be different?
We would give you more detailed costs for anything that we want to get through ratepayers. This is not the time. We don't believe this is the time to settle those issues.
So you take the position that it's not the time to settle the issues, so you think you can circumvent or auditing process?
Absolutely not. We know we're held to the same auditing process in the future.
And just quick question, how much time was spent redacting all these documents?
I have no idea.
Are you planning to bill customers for that too?
No.
So I guess you can enlighten me. If the information is redacted, you've provided no privilege logs, no explanation of the work performed, how exactly is the public staff or the commission supposed to determine the reasonableness or the prudency of the costs incurred?
Twofold. One, I said in my testimony, you all require us to prove that the seller has the ability to convey the title. So we've had to do the legal work. And we don't believe now is the time to determine whether this is prudent or not. So that has been our position consistent through this case.
But you've authorized these payments. When do you determine whether those payments are prudent? Not at the time that you're paying them for services?
No, we believe they're prudent the whole way through.
Do you have contracts with these vendors?
It depends on the vendor. Some, yes. Some is a time and materials basis. It depends on the service being given.
Okay, well, let's talk about McGill and 21 Design. They're largely responsible for some of these due diligence costs. So did you have written contracts with any of those vendors?
I believe McGill we had a written contract with. 21 Design does our quarterback work for the GIS mapping, due diligence materials. I mean, think this system is a great example of a system that has it doesn't have any utility mapping done, nor do they have an accurate categorization of their utility assets. So we had to build all our own maps and all our own, kind of compilation of the assets as they stand.
And Commissioner McKissick, at this time, I'd like to introduce another cross-examination exhibit. It's an email dated October 18, 2023, between Public Staff Attorney Megan Fields and Redbird's counsel Dan Higgins.
All right, we'll mark that as public staff cross direct. Examination Exhibit 5. We'll wait for it to get circulated. Kick shot. Have you had an opportunity to review the exhibit?
No objection.
Without objection, introductions allowed.
So, Mr. Cox, please see the email from Dan Higgins to Megan dated October 18th. Can you read sort of that first line in the email?
I can't, you didn't give me a copy. Sorry?
Commissioner
Yes,
Commissioner McKissick, it was just brought to my attention that this, the subject line reads 401 correspondence, so I'm not sure where your line of questioning is going, but I believe that this is settlement communication.
No.
you might want to address that because if it is,
I'm addressing information that has nothing to do with the settlement.
Well, it's included in an email. And again, I'm not the attorney on this and have not even had a chance to read through the whole email, but I would just note that the subject line does specify that it is a settlement communication. So on that basis, I would object.
and the exhibit clearly states that on the subject line that it's a Rule 401 correspondence communication.
And again, and additionally, I would note that it is referencing Tessie, which is a separate proceeding.
I'm going to sustain your objection.
Thank you.
Has Redbird indicated to the public staff that they have no written contracts with either McGill or 21 Design?
I don't know.
Do you know if those contracts exist?
I'm not in charge of approving McGill or 21 Design invoices with my engineering staff.
I asked regarding the contracts.
The contracts are the same as invoices. They all go together.
So because they all go together, you didn't bother to review either. Is that your statement?
Objection. He didn't testify that he didn't bother to review. I think his testimony was that that did not fall within his job responsibilities.
Would you like to restate your question?
Sure. Did you review any contracts associated with the work?
I don't review engineering contracts.
So with little to no detail on the invoices and no contracts, how does Redbird control the scope and costs of the work performed by these companies?
I disagree with both those. We have lots of detailed invoices. It just happens to be redacted here. And we have contracts with various parties.
That you also didn't bother to provide to the public staff in these proceedings?
I have no idea if you requested that or if we provided it.
So on page 30, lines 16 to 17, you state that due diligence expenses are legitimate business expenses, and this type opportunity cost should be shared with ratepayers. Can you explain what you mean by opportunity cost?
Yes, that mapping these systems, coming up with engineering plans in order to determine what needs to be done to fix the systems, curing title defects, making sure that we have legitimate access to be able to operate these systems, all those things are a net benefit to the ratepayers.
But you provided no oversight for any of these costs.
We provide direct oversight for all those costs.
And what do you mean by oversight?
We have individuals responsible inside the company running each one of these vendors.
But no contracts
It depends on the vendor.
and limited information regarding the work that was performed.
We don't have limited information. We have exact information, including maps, title research, easements, all of that.
But invoices that contain errors,
We have one invoice and thousands of invoices for errors. Sure, we had an error, correct.
and invoices for work performed not related to the Etowah system.
That was one error, correct.
And since you state that due diligence costs should be shared, can you provide out of the $317,000, 269 cents of due diligence expenses identified in Exhibit 4 of your direct testimony, what portion should be the company's share of those expenses?
Objection, that issue is not before this commission today, and I don't think that that's anything my witness is prepared to testify to today.
Could you restate the question so I can make a determination?
Sure. And I would just note that this is in the witness's direct testimony. You state that due diligence costs should be shared. Can you provide out of the $317,269 of due diligence expenses identified in Exhibit 4 of your direct testimony, what portion should be the company's share of those expenses?
Okay, I'm going to allow that question or rule the objection. It is referred to in the direct testimony.
I would say all the expenses are right directly to service to ratepayers. So that would be engineering, that would be GIS mapping, asset inventories, plans, all those.
So is your response then all of it?
I was not prepared today to say that every single one of those invoices, but the vast majority. I would say in the 10 other states that we own utilities, we've never had $1 of due diligence or legal costs disallowed for rate making purposes.
So it is your position that the customers should be responsible for all of these expenses?
Objection, again, mischaracterizing the testimony.
I'm going to sustain the objection if you want to restate your question.
Sure. If the ratepayers pay all, then how is that a shared cost?
If the ratepayers pay all, I believe the ratepayers should pay all the costs that are beneficial to them as customers of the utility.
But you don't agree that the ratepayers should have transparency in this proceeding and know what the impact of those rates are?
I think we've been very transparent about what the numbers are, and we disagree with the way you calculated rates.
How are all of these redacted invoices transparent?
We'll give you the dollar figures. That's what you asked me about.
And no information about the work that was done and how that benefits customers?
What's your question, ma'am?
I'll move on. So let's talk a little bit further about this rate sharing or cost sharing, as you mentioned. Can you tell me a little bit about why Redbird is buying these systems?
Yeah, if it's our mission as a company is to bring safe, reliable, environmentally sustainable water resources to every community in the U.S. So systems like Etowah are the ones that lack access to water resources, as evidenced by their long history of NOVs and compliance incidents. So they fit right into the kind of systems that we buy as a company and turn around.
Is a part of the reason also that it's profitable?
100%. We're an investor-owned utility. We love what we do, but we do not run on love.
So do you agree that with any business venture, or with this, any business venture, there are certain costs associated with doing business?
All business ventures have costs.
And do you agree with Mr. Beckenmeyer's response to public staff data request number 13, question 1B, that due diligence benefits the company?
Objection. Can you please read the entire data request and the full response, or at least provide a copy of that for the witness?
I think that would be helpful and insightful, and if you could refer to it explicitly so it is a part of the record, we want to make sure that that is clear. Don't want anything taken out of context.
Yeah, Commissioner McKissick, I would also note that Jim Beckemeyer is a rebuttal witness, and so I would just question whether this is appropriate for direct or perhaps on rebuttal.
Okay, I'll give her a little leeway here, but she is correct. He will be here on rebuttal. You might want to limit the scope.
Sure, I will. And Commissioner, at this time, I would also like to introduce this as public staff's cross-exam exhibit.
It would be public staff cross-direct exhibit number 6. However, let the record reflect that we sustained the objection on cross-examination exhibit number 5.
Commissioner, just a moment. I think the wrong exhibit, the wrong got handed out.
Okay. We'll be at ease for a few minutes.
Commissioner, I apologize. I will continue this line of questioning on rebuttal.
Okay. Go back on the record and proceed with the witness. This exhibit is understood will be used on rebuttal. You might want to reintroduce it then, but
And thank you for your patience, Commissioner.
it's not a problem.
And just a quick follow-up to our previous line of questioning. It is your position that customers should share costs and your costs of doing business. Correct?
It's my position that any costs that are beneficial to customers, that they should share, correct?
Are customers going to share your profits?
This is a regulated utility. But the improvements that serve the public are entitled to a just and reasonable return. That's the way this is done across the country.
Right, nothing further from me, Commissioner.
All right, we'll recognize Attorney Mc. Oh.
We will switch gears to questions. I just want to, I have a set of questions as well for Mr.
So it's not time to go right ahead if you have additional questions on behalf of the public staff.
Yes, thank you.
Just make sure you identify yourself for the record.
Yes. Attorney James Bernier Jr., public staff attorney, public staff. Good afternoon, Mr. Fox.
Good afternoon.
Wow.
Are you, I think you testified that you're currently the president of Central Water Resources, Inc.
Central States Water Resources, a CSWR LLC.
Okay, Central States Water Resources, Inc., a corporation. It's a corporation.
Correct.
And you testified that you were also the founder of Central States Water Resources, Inc.?
Yeah, I'm the founder of CSWR LLC, Central States Water Resources,
Okay, well,
Inc.
just Central States Water Resources, Inc. is what I'm asking about right now. When was that founded by you?
I don't remember the corporation date of that.
Estimate for me,
9 years ago.
9 years ago. Thank you. Were there any other founders other than you?
I had investors.
Okay, so no other founders?
That's correct.
Presiding Commissioner McKissick, at this time, I'd like to introduce cross-examination exhibit.
Okay, we're going to identify this as public staff cross direct exhibit number 7. Thank you.
You have the exhibit 7 in front of
Hold
you?
1 second. Let's see if there are any objections. She needs a chance to review it.
No objection.
Mr. Cox, you have exhibit 7 in front of you?
I do.
Are you familiar with this document?
I see what it is.
Have you seen this document before today?
Sure.
What is it? Just briefly, one sentence.
It's the annual registration report,
For,
Central States Water Resources, Inc.
okay. And in this document, if you go to box A, you are identified as the president. Is that correct? Josiah M. Cox?
That's correct.
All right. And in box B, You are also identified as a director.
That's correct.
Okay, also directors are Daniel Standen, Tom Rooney, and John Regas.
That is correct.
Did I pronounce those names correctly?
Yep, close enough.
President Commissioner McKissick, at this time I'd like to introduce, this is an exhibit from the testimony of John Hinton, which has been admitted into evidence already.
All right. And this would be,
It's Public Staff Hinton Exhibit 1.
Commissioner
yes,
McKissick, has Mr. Hinton's testimony been admitted?
Yes, he was excused on the motion. I believe that,
Okay, but I don't,
but I don't think we admitted his testimony at that time.
well, we could use this as public staff's direct cross-examination, Exhibit 8.
That would be correct. That would be permissible.
Thank you.
no objection.
Okay. Introductions allowed.
Mr. Cox, are you familiar with this document, Exhibit 8?
I don't have a copy.
Oh, I apologize. Do you have a copy now?
I do.
And do you recognize this document?
I do.
Did you prepare this document?
It was prepared on our half. There's a mistake on this
Okay, well,
document.
let's start with, did you prepare it?
I don't remember if I prepared this. I mean, I've seen this organizational chart multiple times.
Okay, but this organizational chart, Exhibit 8, was produced by Redbird.
Correct.
Okay, now, what's the mistake that needs to be corrected?
Yeah, there's a line, the line's misplaced from Central States Water Resources, Inc. That should be to CSWR LLC.
Instead of US Water?
That's correct.
I'd like to draw your attention in this organizational chart to the North Carolina branch. You see it?
I do.
Great. Now, at the bottom of that branch, it's listed Redbird UOC LLC. Do you see that box?
I do.
That is Redbird Utilities Operating Company LLC.
Correct.
All right, next on the branch is Redbird UHC LLC. Is that Redbird Utility Holding Company LLC?
It is correct.
And one step up, actually, let me take a step back. Redbird Utility Holding Company is a sole member of Redbird Utility Operating Company. Is that correct?
That's correct.
All right, now we go to the next step in the branch. It says North Carolina CSWR LLC. Is that North Carolina Central States Water Resources LLC?
That's correct.
Is the registered name as I just said it, or does it abbreviate CSWR?
I don't know the answer to that. I would believe it just abbreviates CSWR, but I may be incorrect.
Okay. And is North Carolina Central States Water Resources LLC the sole member of Redbird Utility Holding Company LLC?
It is.
Presiding Commissioner McKissick, at this time, I'd like to introduce direct cross-examination, Exhibit 8.
This would be number 9.
Oh, yes, I'm sorry.
So public staff, direct cross exhibit 9.
And it consists of 3 documents.
All right, let everybody receive a copy and review it.
Sir.
Ms. McGrath, you have a copy?
No objection.
All right. Introductions allowed.
Thank you. Mr. Cox, you have Exhibit 9 and it consists of 3 pages, single print side.
I do.
Do you recognize these 3 documents?
I see what they are, correct, yes.
Have you seen them before today?
Sure.
All right, the first page in Exhibit 9 is the the 2022 annual registration report for Redbird Utility Operating Company LLC. Is that correct?
Yes,
Turning to the second page, is that the 2022 annual report for Redbird Utility Holding Company LLC?
yes,
And finally, the third page, is that the 2023 annual report for North Carolina Central States Water Resources LLC?
yes,
Yeah, and then these three are North Carolina LLC, is that correct?
yes, I believe that is correct.
And if you look on each of the 3 pages, Central States Water Resources, Inc. is identified as the manager of each, is that correct?
That is correct.
And is that the same Central States Water Resources, Inc. for which you are the president and director?
Yes, it is.
Is turning back to the organizational chart. The next step up on the chart is CSWR LLC. Do you see that?
I do.
And that is a separate entity from Central States Water Resources, Inc.
That is correct.
And is CSWR LLC the sole member of North Carolina Central States Water Resources LLC?
I believe it is.
And is Central States Water Resources, Inc. the manager of CSWR LLC?
It is.
Are you the president of CSWR LLC?
I am.
Commissioner, I'd like to introduce the next cross-examination exhibit, which I guess would be 10.
It should be number 10, yes. Cute. Without objection, exhibits introductions allowed.
Thank you. Mr. Cox, do you have a copy of Exhibit 10 in front of you?
I do.
Do you recognize that document?
I do.
What is that document?
It's a name change document.
And it's the state of Missouri?
That is correct.
And for what company is the name change for?
CSWR LLC.
Okay, and CSWR LLC is the same sole member of Central States, sorry, had the wrong. Is the same sole member of North Carolina Central States Water Resources LLC.
Say it one more time for me. I apologize.
That was a horrible sentence, so I'll definitely say it. The company, the LLC reference in Exhibit 10, that is the sole member of North Carolina Central States Water Resources LLC.
Yes, I believe that's correct.
And the name change was from First Round CSWR LLC to CSWR LLC.
That is correct.
Presiding Commissioner McKissick, I'd like to introduce Public Staff's next cross-examination exhibit, which would be 11. This is the testimony of Mr. Cox filed in a different docket, W-1328 sub 10. It's the filed document in the docket, so therefore a public document.
They got paid. They got one. Thank you.
Okay, so this is in a separate proceeding.
Correct, in docket numbers 11W-1146 sub 13 and W-1328 sub 10.
Both
That's-
of which you're here in North Carolina.
Yes, this is Redbird in the Tessie transfer docket.
Thank you for clarifying that for purposes of the record.
Yes.
Are there any objection? That objection, introduction is allowed.
Mr. Cox, do you have a copy of Exhibit 11 in front of you?
I do.
Can you turn to the last page, which is Exhibit 1 to that supplemental testimony? There towards I believe the last paragraph, you testify through this exhibit, Central States Water Resources, Inc. is a designated manager of all affiliated limited liability companies, both inside and outside of North Carolina, and exists solely for that purpose. Then it says Central States Water Resources, Inc. has no assets or paid employees and performs all its managerial responsibilities using CSWR personnel. So I have a couple questions. First, do you recognize that statement?
Yes.
Second question, the reference CSWR personnel, which company is that a reference to?
CSWR LLC.
Now, the next question, if Central States Water Resources, Inc., well, actually, do you stand by this statement today under oath?
Yes.
If Central States Water Resources, Inc. has no assets or paid employees and performs all its managerial responsibilities using personnel of CSWR LLC, then aren't they one and the same but for name?
Except my board of directors sits in Central States Water Resources, Inc.
Sorry, can you explain that for me differently?
Yeah, absolutely. So my board of directors, who you brought in the previous exhibit, they all sit in Central States Water Resources, Inc. There are no paid directors. They all sit there in the managing entity.
Okay, do those board of directors have any input on the personnel of CSWR LLC that are being utilized to perform the functions of the managerial functions of Central States Water Resources, Inc.?
I mean, they're my board of directors, so they,
So the answer is yes?
I would say yes.
And I include you, because you are a member also on the board of directors.
That's correct.
So isn't it, well, let me rephrase. So isn't CSWR LLC the de facto managing entity of the three North Carolina LLCs that we've covered?
It's the owner, correct?
Objection. I believe these are seeking legal opinions.
I disagree. He testified he's the president, he's the board of director, and that he have the authority, and it testified as to the personnel being one and the same. So I think this is within his purview. I'm not asking for legal interpretation. I'm asking if it's functioning as that.
I'm going to overrule the objection. The witness may answer the question to the extent he has knowledge relating to what has been requested.
Could you ask again, sir?
Sure. Isn't CSWR LLC the de facto managing entity of the three LLCs that we've talked, North Carolina LLCs that we talked about today?
I don't know what you mean by de facto, but CSW LLC is the economic owner of the three North Carolina LLCs.
Okay. Presiding Commissioner McKissick's, my next few questions go into confidential information, confidential documents.
Okay, well, what we'll do is look to see if anybody who's not supposed to be in the hearing room when the confidential testimony is received could leave at this time. into regular session. Would you like to be recognized, sir, for introduction of this particular exhibit?
Yes, this exhibit number 17 is a web capture of the website for sciencewater.com/about-us. It was taken on November 7th, 2023. And it talks about the identification of the investment team on the website.
All right, and this would be Public Staff Cox Direct Cross-Examination Exhibit number 17.
Yes.
Let's just make sure, Ms. McGrath,
Objection.
no objections. Introductions allowed.
Ms. Cox, have you seen the website that's depicted on Exhibit 17 before?
I don't know if I've been on their website, so not that I remember getting on their website now.
Oh, you did? Okay. John Regas is identified on the website as the chairman and chief executive officer of the Science Water Opportunity Fund investment team. Do you see that?
I do.
To your knowledge, is that correct?
I'm not privy to that. I don't know about their water opportunity fund.
Okay. Is John Regas, does he hold a position, as far as you know, with Science Water Opportunity Fund?
I don't know about the Science Water Opportunity Fund.
Okay. What about Science Water Management LLC?
Yes. No, so excuse me, no. Science Water Management? No, I know Science Capital Management.
Oh, sorry, Science Capital Management LLC. On the website, on Exhibit 17, Daniel Standen is listed as a partner in the Science Opportunity Fund investment team. Same question, do you know if this is correct?
I don't. I'm not privy to Science Water Opportunity Fund.
Do you know if Daniel Standen holds a position with Science Capital Management LLC?
Yes.
What is that position?
I don't know. I just know he's a partner in the firm.
Okay. The website also identified Alex Lukopopoulos. Forgive my pronunciation. I guess your answer is the same. You don't know about the Opportunity Fund, is that correct?
That's correct.
Okay, do you know of his role with Science Capital Management LLC?
I believe he's a partner there as well.
Next is Tom Rooney on the website. Do you know of his role of any, if any, with Science Capital Management LLC?
I don't know his role in Science Capital Management. I know his role as a board member for myself.
In the response to the DR that I read and you agreed with, you said that Science Capital Management LLC is an independent investment firm. What do you mean by independent?
Can you say but just so I make sure I answer your question accurately, can you say it one more time for me?
Sure. Your response to the DR that we read, you said Science Capital Management LLC is an independent investment firm that provides various investment opportunities, etc. The question is independent. When you say independent investment firm, what do you mean by independent?
Yes, that means it's owned by the partners who raise money.
Do you know who the partners are?
I know that Dan Standen and of the Science Capital Management, I know those partners. That's who I originally raised money from.
And Dan Standen is one of them?
That's correct.
Do you know the others?
I don't know all the other partners in the firm. They're the
Okay.
ones that I've dealt with for the most part. And Alex Lukopoulos, I knew ancillary.
As far as you are aware, does Science Capital Management LLC influence the decisions of any of the entities that we on the organization chart? So Redbird Utility, Redbird Holding, CSWR LLC.
The only oversight we get is from our board in U.S. Water Systems LLC.
Does Alex Lukopoulos have any connections to North Carolina Central States Water Resources LLC?
None.
How about U.S. Water Systems LLC?
None that I'm aware of.
What about CSWR LLC?
None, no.
If I said that Mr. Lukopoulos said on a podcast that Central Water Resources, Inc. owns Central States sorry. Oh, I had that backwards. I apologize. If I said that Mr. Lukopoulos said on a podcast that Science Capital Management LLC owns and directs drives the strategy of Central States Water Resources, Inc. or CSWR LLC, would you consider that to be an incorrect statement?
Yes, I would call that a boasting sales guy.
Sorry, you call it?
Call that a boasting sales guy.
Okay. Commissioner McKissick, if I have a moment to confer with co-counsel.
Take a minute.
Thank you very much. The public staff doesn't have any other direct response questions.
Okay, thank you. Ms. McGrath?
Yes, thank you. Just a few questions. Mr. Cox, when you started out, Ms. Newell asked you a number of questions related to an acquisition adjustment. Mike, do you remember those questions?
I do.
As part of this proceeding, is Redbird seeking approval of an acquisition adjustment?
No, we are not.
You were also asked a number of questions by Ms. Newell. I think they were related to the Pine Knoll Town 2 system and some violations associated with that system that perhaps may currently still be in existence. Do you remember that line of questioning?
I remember her asking about that systems. Yes, correct.
Okay. And is it accurate to say that CSWR's business model is to purchase distressed facilities that may have a number of violations?
Yes, I believe 98 or 99% of all systems we bought have some form of distress.
And does it take time to remedy those conditions?
Absolutely does.
And when you acquire a facility that is currently in distress and has a number of violations, is it accurate to say that you begin taking steps as soon as possible to begin remediating those conditions?
Absolutely. We go kind of through two phases of investment. We do what we affectionately call triage work. So we bring the systems back into just operational, just operating. The electrics failed, mechanicals failed, there's safety hazards. So we're trying to remedy all that as quickly as humanly possible. And then that kicks off a whole nother set of permitting, final engineering design, that kind of stuff to bring a final remedy to each system.
So it would be virtually impossible on day one of acquiring a facility to bring it into compliance.
Well, that's correct. So our agreements with various environmental regulators stipulate typically, 24 to 48 months to bring them into compliance.
Ms. Knoll asked you a handful of questions related to the purchase price of the Etowah system and whether or not that purchase price was prudent. And she also suggested that since the agreement was entered into in 2019, that those facilities would have depreciated. Do you remember that line of questioning?
I do.
Would it also be fair to say that with the passage of time, that there would be additional issues that would require attention, that would need improvements, perhaps additional due diligence costs that would be incurred that may impact a purchase price?
Absolutely. I mean, I definitely a due diligence point. I think I mentioned this earlier, you know, since we've signed this purchase contract, there's been 11 notices of violation with this system. In fact, the Department of Environmental Quality called us about a continuous sanitary sewer overflow. So there, a lot of things happen with the passage of time.
And does Redbird buy systems at net book value or market value?
Market value is what we buy as systems, we believe.
And does market value depreciate?
Market value does not depreciate.
So I'm going to turn to some of the questions that Mr. Bernier asked related to the corporate structure. And one of the exhibits he provided you is cross exhibit number 8, and that is the organizational chart. Do you have that handy?
A couple organizational charts. So what was the front of that?
This is just a one-pager
Okay.
blue chart,
I have it.
and I can actually just talk you through this. Do you recall testifying that you thought that there was a mistake on this organizational chart?
Yes, because I believe Central States Water Resources, Inc. is the manager of CSWR LLC was the thing I was trying to clarify in this.
And if I said that subject to check that perhaps this may not be a mistake, would you accept that statement?
Sure, if this was an ownership chart rather than a management chart, then I would agree.
And that perhaps Mr. Beckermeyer may be able to clarify if there's a mistake on here or not.
I love when the attorneys clarify. Yes, please.
Okay. Okay. You were asked a number of questions and shown a number of exhibits related to the corporate structure. One of those exhibits is number 11, and that was your supplemental testimony that you filed in the Tessie matter. Do you recall that testimony in that particular exhibit?
I do.
Okay. And do you recall the purpose or one of the primary purposes of filing this supplemental testimony in that proceeding?
Yeah, that was filed to support.
Because I think going into the purposes of filing. Sorry, I would object. I think going into the purpose of filing goes into the settlement discussions. And if council wants to open the door to settlement discussions, then I'm all for that. But at this point, I'd rather object.
Oh, could you restate your question, please?
Sure. Can I refer you to page 4 of your supplemental testimony filed in the Tessie matter?
I have it.
Okay. And at the top of page 4, the question reads, did public staff request that Redbird address certain issues in this supplemental testimony? And you respond and you say, yes, in the next several Q&As, I present this information. Is that right?
That is correct.
Okay. And the first question says, please describe the relationship between Science Water and/or Science Capital Management LLC and U.S. Water Systems LLC. Do you see that?
I do.
And you provide information about the various ownership and structure in the next handful of questions. Is that accurate to say that?
That is correct.
Okay. And you were at that hearing, were you not, Mr. Cox?
Sitting right here.
And did you hear Mr. Hinton testify in that proceeding?
I did.
Would it be accurate to say that Mr. Hinton concluded that Redbird did in fact have the technical, managerial, and operational qualifications necessary to own a public utility system?
That is correct. That's what he said in my hearing.
And that any concerns public staff may have had about the structure of CSWR or the funding or confusion about the corporate structure, that those concerns were alleviated?
That's what he said.
Then
Okay.
I think to substantiate that, we would need the testimony from that hearing. Otherwise, I challenge the accuracy of counsel's characterization of that testimony.
I'm going to overrule your objection at this time.
Thank you, Commissioner. We could also take judicial notice of that transcript.
We can do so, and that would be duly noted.
Thank you. Mr. Cox, I'm going to go back to some of Ms. Knoll's questions about the invoices that we went through. And I think you acknowledged that on at least one of those invoices, there may have been an inadvertent inclusion of a different matter. Is that accurate to say?
I believe that's accurate, yes.
Okay. And at the time of a rate case proceeding, when you are seeking recovery of costs, is it accurate to say that if any error was brought to your attention, that you would make whatever corrections were necessary
Absolutely.
and remove any expenses that were inadvertently included?
Yeah, absolutely.
And if public staff were to request unredacted versions of any invoices, would Redbird oppose providing those to public staff?
Not if we expected to get them included in rate base.
On public staff direct cross exhibit number 2, this is an invoice from Burns Day and Presnell. Ms. Knoll asked you about some references to tribute. And I think another reference was to tribute RV development plans. Are you aware of some of the consumer concerns that were filed at the public hearing in this matter?
I am.
And did a number of those concerns relate to a proposed development?
They did.
Do you recall what that development was called?
In retrospect, I believe it may have been this tribute park.
Okay, and so that would be related to the Etowah system?
That is correct.
Okay. So to close the loop on that, that would mean that this invoice is actually accurate?
That is correct.
Okay. Nothing further. Thank you.
All right. We have a few questions here. Let me first ask you, Mr. Cox, some questions that are from commission staff related to your testimony, your direct testimony. Now, on page 28 of your direct testimony, in support of your argument that the commission need not decide rate base, you argue that such deferral is analogous to the treatment of Redbird's interim cost in the Ocean Terrace / Pine Knoll Towns docket. Do you have any precedent of the commission deferring the issue of rate base itself?
I'm sorry, Commissioner, I'm not an attorney. I don't know the answer to that question.
Okay, that's fair enough. Let me ask you a few questions about what I refer to as kind of the capital structure and financing that's proposed as it relates to this proposed transaction. In your direct testimony on page 17, you state the company has invested more than $450 million in systems through equity, and that you plan to pursue debt financing at the appropriate time. When do you contemplate the appropriate time may be?
Yeah, so Etowah is a great example. So like Etowah is losing cash every year, and Etowah also has compliance issues. So they're effectively unbankable. So no commercial financing institution will loan money to Etowah. So what we've done historically is, do the improvements necessary to bring safe and reliable service to the systems, come in for compensatory rates, and then once we get rates, we go and get debt financing. Absolutely, we go through the debt, financing approval with the commission, but that's how that works for us.
And I believe in your testimony, you refer to perhaps if this acquisition is allowed and permitted, that about 33 months out, you would anticipate petitioning for uniform rates.
That's correct. I mean, depending obviously on the length of time these acquisition cases, but we're a number of years out before we come back for rates, just because we have to do all the improvements necessary to bring the service back into compliance.
Okay. Now, Redbird says that ultimately the capital structure will be 50% to 60% equity and 40%, 50% debt. When do you anticipate that will occur?
We've done it once the rates are in place and we have cash flows to support commercial financing.
So that would be perhaps somewhere beyond this 33 months that we're talking about.
That's correct. It would be after a future rate case.
All right. Can you provide the commission some insight into the company's business plans and need for external financing?
Yeah, that goes back, Commissioner, we talked about we don't get external financing. We fund it all with equity. So, and we've done that in a number of states. Once we finish rate making, we go and get debt for the individual state utilities.
All right. Now, how long will the company's current plans and contracted acquisitions continue to require equity infusions from scions or?
So U.S. Water Systems will have to keep putting cash into all these systems. We'll have to keep doing cash until we get compensatory rates. So a number of years out, just because all the operations are cash flow negative in the state of North Carolina.
And can you speak to the nature of the capital science has access to? Is it a committed pool with a life long enough to see through these investments, and are investors able to withdraw it on demand?
This is long-term capital. It's institutional investors, and we've shown that. We've been in business. I mean, we're almost 10 years old as a company and been partnered with science for about 5 years. So we've, invested $400 million in buying and improving systems and spent $50 million covering the operating loss you're referring to, Commissioner.
All right. Now, on page 28 of your testimony, you state that changes to North Carolina General Statute 62-111 enacted by the General Assembly during the last legislative session now provide that the commission shall issue an order approving an application to acquire water and wastewater system assets if the proposed acquisition is in the public interest, will not adversely affect service to the public under any existing franchise, and the person acquiring said franchise has the technical, managerial, and financial capabilities necessary to provide public utility service to the public. By limiting the focus of the commission's inquiry to acquisition cases, I believe the General Assembly has signaled that extraneous issues such as whether an acquisition adjustment should be approved should be deferred to rate and other post-acquisition proceedings. So let me ask you this. What is your objection to the commission determining the rate base and whether any acquisition adjustment should be allowed in this proceeding.
I think it's the same, sir, as we talked about with the due diligence costs. We'll have to prove all that each thing was in the customer's benefit. For example, if we bought Etowah and we didn't do what we've done historically all over the country, didn't turn the system around, obviously we would not be entitled to any type of premium, much less in recovery of any costs. So that's the way we view that.
And I believe in your direct testimony, initially you sought a portion of an acquisition adjustment in this proceeding, but you changed that later. Is that correct?
I think
Subject to check.
subject to check. We're no longer asking for that in this hearing, I believe. Correct.
So is there a reason why the commission should not determine the rate base in this proceeding? Is there a reason the commission shouldn't establish rate base in this proceeding?
We don't believe all the details are in on this.
Do you believe that Redbird would be adversely affected by the commission making that determination in this proceeding?
We believe it would hurt us to demonstrate that we can provide a significant public benefit in the future.
And can you point to any language in the statute or elsewhere that indicates that the General Assembly didn't intend the commission to determine the rate base and any acquisition adjustment in a transfer proceeding?
So I'm a simple man here, Commissioner. So just my plain reading that statute seems to say it's all about not adversely impacting the customers in the near term, not changing rates, and showing that you have a qualified utility that would be good for the customers to have.
You cannot point to any other language.
I'm not an attorney, sir. That's my.
I respect that. And lastly, in terms of the application in this case, Redbird's application, it came in, but then there were a number of occasions where there were deficiencies and supplemental documents were submitted. Now, as I recall, the application was deemed complete on September 14, 2023. Is that consistent with your recollections, subject to check?
Yeah, I believe that's the first time that we were told that it was complete, correct?
Okay. Let me see if Commissioner Duffley or Hughes have questions of you.
Just have a couple.
Good afternoon.
Good afternoon.
So I wanted to follow up on a question that public staff was asking of you regarding the, I don't know if that was confidential, but a number of due diligence costs. And she was asking whether those were going to be put into rate base. And your response was something to the extent of and she was talking about shared costs, like, so these due diligence costs, when you finally seek them, would be shared. And she was trying to obtain what percentage was shared. And you stated that obviously, in your opinion, if it was beneficial to the ratepayers, then you would seek to recover them from the ratepayers. So sitting here today, what percentage are we talking about? Is it 50%, 10%, 5%, typically that you've seen with your past experience that would be shared by the company?
Yeah, so that would be, thank you, I understand, Commissioner. So the majority of those costs, because they relate to specific improvements, we typically put into rate base. So imagine we do a GIS map of all the distribution lines, and then we use it for providing service. We capitalize that with the distribution system, for example. The costs that we don't share would be pure administrative costs. So you think contract formation or anything like that, review meetings that are not specifically tied to an improvement or the transaction for the customers themselves.
Okay, and based upon your past experience, typically is it 5% of total costs, 10% that the company would not pass on to ratepayers?
Yeah, I would say we don't even submit, 10 to 15% of the costs when it all shakes out.
Okay, thank you. And then Commissioner McKissick was talking with you about how initially the company may have sought an acquisition adjustment decision, but now you're saying that it's going to be within the next rate case. But initially, you had talked about the approval of an acquisition adjustment for a reasonable portion of that premium. And so typically and so I'm not saying the number, but you know, that premium paid, typically what does reasonable portion mean to you? Is it 25%, 50%, 75%?
You know, it's interesting, Commissioner, when we first came to the state, one of the things that attracts us to the state was a previous deal. It was that Heater Utilities was acquired by Aqua American, which is now Essential Utilities. And when Aqua acquired Heater, there was this agreement for, you know, recovery of acquisition adjustments. And it had to do with how many dollars were invested by Aqua in the Heater Utilities. They had some formula, if I recall. Don't quote me on this. Again, I'm not an attorney, so, but I'm just as a business, leader in this company. That seemed like a really fair way to view it. So the dollars we're putting into the ground directly correlated to dollars we could recover on an adjustment because it showed they were direct benefit to the customers. So that's one of the examples that we saw coming into North Carolina.
Okay, thank you for that response. I appreciate that. And then you also mentioned in one of your answers to Commissioner McKissick, you know, the standard of what do you consider adverse impacts to customers. And the public staff has concerns, it looks like, about the increase of rates. Understanding rates may have not been increased for a period of time, but do you consider increased rates or significant increase in rates to ratepayers, would that be considered adverse impact to customers? And if so, or if not, at what point does it become, if you're going to say, no, it's not an adverse impact, at what point does it become an adverse impact to customers?
Yeah, that's great. Great question, Commissioner. I'll get to the adverse thing because I have a direct answer on that. I think one of the things that's for us frustrating as a company, unfortunately, everyone's sitting around this table. The majority of your work is electric and gas. The majority of those customers are investor owned, and the percentage is much smaller on for water companies. And I think that the level of service that's tolerated for water and sewer companies, because it's kind of the backwater of the regulatory world, is so low. And that's not just in North Carolina, it's across the country. And just because so few of these issues get brought before commissions. And so when we say things like human pathogens are released into the environment, right? That's a huge deal. I mean, if you look at the World Health Organization, centralized sewer is the greatest contributor to an increase in human life expectancy in world history, right? Because we removed all these pathogens from the natural environment, so people quit getting sick. So for us, like, what is the human health benefit to all our customers or the stability of service? It's a lot. I think anyone would say being able to flush their toilet and be safe and turn on their faucet is worth a lot of money. So there's that. For us, we use for an adverse impact. So the EPA has guidance on what they say is oh gosh, I'm getting the verbiage wrong. It's not adversity. The word will come to me. But basically, the EPA has said 2.5% of median income if the water rate is above 2.5% of median income, then it's a hardship. And on the sewer side, it's 2% of median income. So that's the way we look at the world, is we want to be beneath those impacts so we're not adversely getting our customers.
Okay, thank you. And then you had a conversation with public staff about the risk, right? Tell me if I'm getting into confidential information. Is it just the numbers of the APA that are confidential, not the terms?
That's correct, ma'am.
Okay. So there was some discussion about when the buyer could basically back out of the deal. But I think once you close, the deal is done, right?
That is correct.
And so, under how you have it right now, all of the risk will be on Redbird in a future rate case. Is that accurate?
That is correct, Commissioner, and that's one of the primary benefits I think we bring to to a community is we are shouldering all of that risk, and it's our belief that years from now in a future rate proceeding, that the quality of service will be so improved that everyone will recognize the benefits that we brought, and that's the experience we've had in all the other states we operate in today.
Okay, and hypothetically, let's say that a future commission, maybe not even made up of this panel sitting here today, denies all of your due diligence cost and denies all of the acquisition premium. What's your recourse?
There is none. The investors would bear that loss. Honestly, the only thing that happens in that scenario is that future investment in North Carolina will be looked on more skeptically. But nothing happens in terms of benefit to customers, nothing happens to quality of service, any of those items.
Okay, thank you. And circling back to the adverse impacts to customers. So you're saying that the customers let me make sure I understood your answer. You're saying that the customers will have adverse impacts if their sewer bill is greater than 2% of their take home?
That's correct, ma'am. That's the way we've used the EPA's guidance on that.
Okay. Okay. Thank you. Nothing further.
Commissioner Hughes?
Thank you. If I can just try to put together all the pieces of what you've said and just to make sure I'm understanding. 'Cause I think there's a lot of subtle language we're using. The due diligence discussion about shared or what you were pretty adamant that, and I think you used the phrase, not a single dollar had been denied in all your other kind of experience. Is that's a single dollar of due diligence that you, the company, has determined in a rate case that is worthy, that you've presented forward? Is that what you're saying?
Thank you for clarifying, Commissioner. That is correct, that we applied for in rate proceeding.
Okay, and then to piece that together, what you told Commissioner Duffley, in general, the bulk of the due diligence that's floating around is presented as being beneficial to customers, whether it's 85% or 90% or 95%, but just the bulk.
That is correct, sir.
Okay. And then again, since you broke out, you brought up in a number of statements how other states deal with Redbird or central states and how that kind of went into your risk equation. On the acquisition adjustment, have other states been open to the same type of acquisition adjustment approach that you put in your testimony early on? I know you've pulled back a little bit from that, but I think you used the term reasonable portion so again, I don't have specifics, I just have all these adjectives, but in other states, has that, would you say that no states denied a dollar of your quote reasonable acquisition adjustment, or has that been a little bit different?
We're pretty close, Commissioner, on that. Obviously, it's interesting, we would postulate, we said this when we first came to North Carolina and, we got shot down immediately. We think the books and records of these companies are terrible, right? They're not reflective of what's actually in the ground. We've proposed using, net original cost studies. That's why we brought real estate appraisals because real properties typically never been included in rate base and should have been at the inception of the utility, a bunch of other factors like that. So everyone hates the word acquisition adjustment. So do I. So I understand that. Other states have things like deferred debits. Probably Commission's familiar with fair market value legislation we've utilized, but then we've also utilized alternative evaluations of the purchase costs. But to answer your question directly, yes, the vast majority, maybe 95, 98% of our acquisition the acquisition dollars paid to sellers have been recognized for rate making purposes.
And has that generally been done at the time of closure, or has that been done, at the time of rate case?
Always the time of rate case. Now, fair market's different because they give you, so fair market, excuse me, I want to correct that statement. Fair market is set at the time of closing, and I think the only state we're using fair market in is Texas. Arizona's deferred debit is an indication, which is future leaning, and all the rest have been done in a rate proceeding.
Okay. Well, now to pull it all together, I think there's also been debate about what's meant by public interest. Would you agree that the public is quite interested in what their longtime payment for water and sewer services are going to be? That is something that they're at least interested in?
Absolutely, sir.
So it would seem, given all of this, that your expectation when you looked at this as a financial endeavor and the risk is that whether it's done now or done in 3 or 4 years, that the quote acquisition adjustment would be incorporated into rates, and the due diligence costs would be incorporated into rates. That was at least an expectation based on past experience.
Yeah, I refer back to the heater thing that I talked about earlier. We saw
Even in the
yeah, and I would say also, Commissioner, we've never had anyone try and bring due diligence costs in acquisition proceeding ever. So obviously purchase costs, I understand, but acquisition, the due diligence costs associated, because we just assume that all the real property and engineering has to be tied to assets in providing a benefit.
Okay. So with all of that said, if I'm not looking for an exact number, but I'm trying to figure out 3 or 4 years down the road, a rough range, so I can do that calculation you discussed or any other calculation, the public staff went to a fair amount of effort to convert a hypothetical acquisition adjustment and a hypothetical due diligence cost impact on rates using the way we set rates. Have you seen those numbers in their testimony?
I have.
Okay, so are those numbers reasonable shot in the dark things to pull into our understanding of what the rates might look like moving forward under your expectation?
Can I answer that kind of twofold? I would say one, consolidated rates are really important, we think, for small water and sewer in particular, because, system A may have more improvement costs today because they're in a greater sense of distress, but system B is going to have the same improvement costs over a 10-year time period, and all the costs even out for all the customers. So that mitigates rate impacts. I would say, Commissioner, our rates across the country, range from, and this is post improvements, they range from, $45 to $75. I think my high, somewhere in that range is I believe is correct in terms of what we're seeing final rates on a consolidated basis across the state come in at.
Last question. I appreciate all this. So you brought up consolidated rates of all of these other central water states comparison group that you're using to assess your risk. How many do you have consolidated rates in?
We have consolidated rates in 5 states currently, and then we've got, I think we're soon to be awarded a 6th state that's kind of in process.
Thank you.
Commissioner Duffley.
So you mentioned small water companies. Let's assume that all of the pending transfers go through. Will you still be considered a small water company?
No, we don't believe in some future case we'd be considered a small water company.
Okay, thank you.
Now have questions on commissioner questions.
Nothing from the public staff.
Nothing from the public staff?
I have a couple, Commissioner
Okay.
McKissick. Mr. Cox, Commissioner McKissick asked a question about whether or not you were aware of any precedent of deferring a determination on rate base. Do you recall that question?
I do.
And you're familiar with the recent statutory change in North Carolina, are you not?
I am.
Okay. And um, and so perhaps given the recency of that statutory change, would it be fair to say that perhaps the commission's assessment of a transfer application would be different and not address rate base?
I believe that's the way, why we refile it the way we did.
And you were also asked questions about, if you had any, what is Redbird's objection to deferring a determination on rate base or due diligence costs, or an acquisition adjustment? Sitting here today, pre-closing, do you have, well, first of all, you don't own the system, correct?
That's correct.
And do you have all of the information you need in order to put a value on those types of issues?
No, we don't. We believe we have incomplete information at best.
And at the time of a rate case proceeding, post-closing, when you are the owner of the Etowah system, would it be fair to say that you would have additional information and that the record would be more complete?
That's my experience in all the systems we buy.
And you were here at the outset of the hearing during public staff's opening remarks, were you not?
I was.
And many of those opening remarks were focused on the value of the acquisition adjustment and the rate base and the cost of due diligence costs, were they not?
They were.
I'm objecting to this line of questioning, Commissioner.
You want to state the basis for your objection?
Between the line of questioning and the commission's questions.
Can you restate your question?
Yes, Commissioner. You were asked a question by the commission about maybe questioning why, if we're not seeking approval of an acquisition adjustment or approval of due diligence costs in this proceeding, why your testimony provided some discussion of these matters. Do you recall that question? And forgive me for paraphrasing.
I don't recall that question from the commission.
It was paraphrasing the question, but I believe that there was a line of questioning about how the testimony included information about the acquisition adjustment and the due diligence costs, despite the fact that we are not seeking recovery of those in this proceeding.
That would be correct. So I'm going to overrule your objection at this time, but let's try to keep it pretty focused.
Yes,
We're going to try to
absolutely.
conclude this hearing today.
My only question is would it be accurate to say that public staff's opening remarks were focused on these issues?
Yes.
Okay, and so knowing that that was an issue that public staff had, would it be accurate to say that that is why we included some information in your direct testimony?
That is correct. That's why we have that in the direct testimony.
Thank you. Nothing further.
Okay. It's my understanding at this time, this is the only witness the applicant has for direct.
Correct.
All right. Are there any motions that need to be made at this time? I believe you moved his testimony
Okay,
into
okay, I
the
was just gonna
record, but
check.
let's just make sure.
Okay, I was gonna do the At this time, Redbird would like to move into the record Cox Direct Exhibits 1 through 4 into evidence, excuse me.
Without objection, it's allowed. I think we did it earlier,
Okay.
but as a
Just to be sure.
precautionary measure, we'll make certain that is the case.
Thank you. Nothing further.
Thank you. Public staff?
The public staff moves to admit into the record, public staff's direct exam exhibits 1 through 17. 17, yes.
Okay,
And Commissioner McKissick, was it number 5, I think, was
Yes.
over,
we did overrule, and I will go back and see which one that was.
It was number 5.
okay.
Yep, was number 5.
So,
And I believe number 6 was one that it's going to be probably readmitted on rebuttal. Is that right?
Yes.
Okay.
Yes.
Without objection, motion's allowed.
Thank you.
You may step down from the witness stand. Watch your step.
Thank you.
Oh. And okay, let me ask one thing. In terms of the application and the company report, we probably should have those officially admitted if you would like to make a motion to do so.
Yes, Commissioner, we would like to move the application along with the supplements to the application.
I remember some company reports being in the record.
Yes, and I'm sorry, one additional thing, the verified report for the public hearing, we would like to move. into the
Exactly.
record. Thank you.
Without objection, that motion is allowed. Okay. Recognize public staff.
Yes.
I think you have a panel.
The public staff calls Lynn Fiesel and Michael Franklin as a panel.
Now, let me just ask one question at this point. I know we as commissioners, I understand that the attorneys don't have a problem continuing today to conclude this matter. I did not ask that question of our court reporter. If we go on beyond 5 or 5:30, is that a problem for our court reporter? It is not. And I don't see where any staff or anybody in the room is stating any problem. So we're just going to go ahead and conclude this case today. All right, you may proceed.
Commissioner, if I may, before we proceed, just sort of in terms of time that we had.
I believe you, yes, go right ahead.
So I was just sort of making, getting a sense of how much more time we would be proceeding today, because I believe we've got 40 minutes reserved for the cross of this panel.
We need maybe 10 minutes.
Okay, it's only 10 minutes. That's good. And I'm seeing for rebuttal is 120 minutes.
It would be less.
We can cull it down.
Okay, that's why I was concerned earlier. We'd certainly want to conclude this before midnight or 9 p.m. Okay, I don't mind, keeping going for a while, but not for 2 hours of rebuttal unless that's absolutely essential, in which case we will come back tomorrow.
No, we had originally budgeted some of the questions on the structure in the rebuttal, and then we thought it best to do it into the rec. So the rebuttal would be substantially less than 120.
Thus is the reason you name one of your exhibits rebuttal.
Indeed.
Understood. I think we're operating under the same set of assumptions, so you may go ahead and proceed.
Ms. Fiesel, can you?
Oh, let me do one thing. Let me get you under oath. If you both could put your left hand on the Bible, raise your right hand. Do you swear that the testimony you're about to provide in this proceeding will be the truth and the whole truth? So help you God.
Yes.
Okay, you may
Yes.
proceed.
So I'll start with Ms. Fiesel. Can you state your name, business address, and position for the record, please?
Yeah, my name is Lynn Fiesel. Business address is 430 North Salisbury Street, Raleigh, North Carolina. I'm the Public Utility Regulatory Manager of the Water, Sewer, and Telecommunication section with the Accounting Division of the Public Staff.
And Mrs. Fiesel, on October 27th, 2023, did you prepare and cause to be filed in this docket testimony, a public and confidential version consisting of 7 pages, an Appendix A, and 4 exhibits, each with schedules herein, marks Public Staff Fiesel Exhibits 1 through 4?
Yes,
And do you have any changes or corrections to your testimony?
no,
And if I were to ask you those same questions today, would your answers be the same as in your pre-filed testimony?
yes,
And Presiding Commissioner McKissick, I move that Mrs. Fiesel's direct testimony be copied into the record as if given orally from the stand, and that Mrs. Fiesel's appendix and exhibits 1 through 4 be identified as marked when filed.
The pre-filed direct testimony of speaker will be received and completed form and exhibits your testimony, pre-filed direct testimony identified as a mark.
Thank you, Commissioner. And Mr. Franklin, can you state your name, position, and business address for the record?
Yeah, my name is D. Michael Franklin. I'm an engineer with the Public Staff, Water, Sewer, and Telephone Division. My work address is 430 North Salisbury Street, Raleigh, North Carolina.
And Mr. Franklin, on October 27, 2023, did you prepare and cause to be filed in this docket testimony, a public and confidential version consisting of 25 pages and an Appendix A?
Yes,
Do you have any changes or corrections to your testimony?
no,
And if I were to ask you those same questions today, would your answers be the same as in your pre-filed testimony?
I do have an addition related to page 8, line 7 of my testimony, pre-filed direct testimony. It has to do with the public staff receiving any consumer statements of position. At the time my testimony was filed on October 27th, since then, we have received 7 additional consumer statements. In fact, 2 were received today, actually. All expressed concerns over future rate increases as a result of the transfer, with 1 expressing an additional concern regarding the new subdivision being planned that included a possible new wastewater treatment plant and the impact that would have on the community.
All right, the pre-file direct testimony of Mr. Franklin as amended and notated through his testimony today will be received into evidence and treated as if given orally from the witness stand. The attached exhibits to his pre-file direct testimony will be identified as it was marked when pre-filed.
Thank you, Commissioner. And if I may take leave at this time to move the pre-filed testimony and exhibits.
Of Mr. Hinton.
Mr. Hinton, consisting of 5 pages, an Appendix A, and 1 exhibit.
All right. And I believe the applicant had no objections to that.
No objection.
So we would admit Mr. Hinton's pre-file testimony consisting of 5 pages, Appendix A, which is 3 pages, Exhibit 1, which is 2 pages. And we will admit his pre-file direct testimony into evidence, and it will be treated as given orally from the witness stand. The attached exhibits to his pre-file testimony will be identified as it was marked when pre-filed.
Thank you, Commissioner.
You may proceed.
And Mrs. Fiesel and Mr. Franklin are available for cross-examination and questions from the commission.
Attorney McRae, the witnesses are yours.
Thank you. Good afternoon, Ms. Fiesel. I'll
good afternoon.
start with you. I just have a few questions for you. You have served as the accounting witness for public staff in prior water rate cases, correct?
Yes,
And so you're familiar with the information needed to establish rate base
yes,
in a rate case.
yes.
And can you describe some of the type of information that you need in order to establish rate base?
I can start with the components that is included in the rate base. Includes planting service, accumulated depreciation, which reduce the rate base, takes that effect, CIAC, amortization of CIAC, existing PAA, amortization of existing PAA. Those components gives us the net plant value. And also on top of that, we will also have cash capital, cash working capital, average tax accrue. Also depending on the size of the company, some company has ADIT, house free capital, sometimes EDIT, but that does not apply to all companies.
Okay. And Redbird currently does not own the Etowah wastewater system sitting here today, correct?
Currently, they do not own.
Okay. And you would agree that Redbird would be in a better position to supply some of the information that you just walked through, particularly with respect to plant and service, once it owns the facilities?
I believe when we ask a data request, Redbird contact with the seller and get information from the seller.
Okay. And Redbird can only supply to public staff information that it either has or it receives from the seller, correct?
I think so.
Okay. Thank you, Ms. Fiesel. The remainder of my questions are for you, Mr. Franklin.
Okay.
And I'd like to, my questions are really focused on the application process for a transfer application. So would you agree that the application requires a variety of information? And I'll read through a couple of things and you can let me know if you agree. Information about present and proposed rates,
Yes.
the buyer's qualifications and financial information.
Yes.
And then it also requires the applicant to provide some pretty specific information about the property that is proposed to be acquired, such as ownership rights or easement rights.
We typically ask that in a data request. It's not part of the application, I don't believe, as far as easements.
Okay. So subject to check, let me just bear with me here one moment. So I'm not going to mark an exhibit, but I'm going to read. So would you agree that some exhibits are requested as part of the application process to
Yes,
be
that's correct.
to be attached? And subject to check, I'm just going to read number 4 on page 8 of the application, which lists exhibits, and it says, enclose a copy of exhibits showing that the seller has ownership of all property necessary to operate the utility and a purchase agreement reduced to writing. Does that sound familiar to you?
It does, but you had mentioned easements, and
Okay.
easements not ownership.
Okay, I'll rephrase. That one of the showings that an applicant is required is that it will, that the property that is sought to be obtained, that the seller currently owns it.
That's correct.
Okay. So specific to this proceeding, in order for Redbird to make this particular showing, that the seller has ownership of all the property necessary to operate the utility, I would think that it would have to demonstrate that it has easements to the utility property.
Yes, I mean, we asked that in a data request.
Okay. And in fact, Redbird's failure to do so in some instances has resulted from a deficiency letter from the public staff, has it not?
Not specifically on easements. I'm not sure on all of the deficiency letters what the issues were.
Are you familiar with the Meadowlands proceeding involved Redbird's application to acquire the Redbird property?
I'm not familiar with Meadowlands.
Okay. Would you accept, subject to check, that public staff has issued deficiency letters related to Redbird not having presented evidence that it owns a list of fee interests and or easements related to lift stations?
Subject to check.
Okay. And would you agree that the commission's requirements for demonstrating ownership are the same regardless of the size of a utility being acquired? And that one of the purposes of conducting due diligence is to prove ownership and easement rights? Would you agree with that?
I would say that as far as what we allow as due diligence is typically closing costs, and that would be a cost that we would expect the company to absorb as a cost of doing business.
Okay, but would you agree that one of the purposes of due diligence is to verify ownership?
I would say that that is a company cost portion of due diligence because there's no benefit to the customer.
Okay, but I'm going to ask it again. One of the purposes of due diligence, regardless of who the cost is recovered from, but one of the actual purposes of going out and conducting due diligence is to verify ownership.
I would agree.
Okay. And I think you testified that due diligence costs include closing costs?
That's correct, typically.
Okay. And the Etowah transaction has not closed yet, correct?
That's correct.
Thank you, Mr. Franklin. That's all I have. Nothing further.
Let's see.
I have some redirect on the
Okay.
accounting side. Ms. Fiesel, one of the questions you were asked regarding and this is me paraphrasing, whether Redbird would have access to information to help them determine rate base at this point when Redbird isn't an owner of the company. The question I want to follow up on with that is, what are the sources for determining rate base? In other words, I'll start with that. What are the sources for determining rate base?
Commission website is one of the sources the company can go to, because Etowah filed a rate case last time, back in 2014. So Redbird is able to go to the commission website, find out what was approved for the net plant in the last rate base. Starting from there, then the company can search for additional plant information from the seller.
Okay, and what about annual reports from Etowah? Are those available?
Yes, they are.
When, how?
I believe annual reports are public records, that Etowah filed annual reports every year, sometime in April, late April. I believe the company is able to request the annual reports from the seller, review those reports, and see whether the plant value from all those reports are comparable to what they pay for the purchase price.
Okay, so is there any reason why the company would not be able to determine rate base until it owns the system?
No, there is no reason. Company has the resource to do the research.
Commissioner McKissick, I'd like to introduce a confidential exhibit that goes to this as to the components of rate base, and it's a summary exhibit from Ms. Fiesel comparing the company's calculation to the public staff's calculation and explaining the difference.
We need to go into confidential session.
Yes.
All right.
Commissioner
Yes.
McKissick, I'm going to object. I'm not sure this is appropriate for redirect.
To
Introduce
be
you.
honest with you, I had some questions
Yeah.
about that as well.
The reason.
I would have thought you would have addressed this earlier. I mean,
My basis
yeah,
is that I could serve for rebuttal on the company, but truly, the applicant has raised the question on direct as to what are the components of rate base. That's the direct quote from one of their questions. They asked Ms. Fiesel as to the components, and she went through the component plant additions. I think she said depreciation. I think to further highlight, to summarize what's at issue here is what this exhibit tries to get at.
Commissioner, I'd like to respond if you'll permit. The purpose of my questioning was nothing more than to elicit the response that prior to owning a facility, you would not have the amount of information that you would have once you actually own it, including plant and service.
And this exhibit actually goes to that because it shows, in addition to what Ms. Fiesel just testified, it actually shows the actual numbers that are available to the company before it even owns it. So it undermines directly the purposes that a council is trying to achieve.
you think you can deal with this on rebuttal?
No, because it's Ms. Fiesel's work product, it's something she made to explain the differences.
And again, Commissioner, I would say this is an issue that would have been appropriate on direct.
It's in her direct testimony. It's just as a summary exhibit to show what's on this exhibit is in all direct. It just brings it together in one handy exhibit.
So it's already in the record then?
Yes.
Then we will observe it as being duly noted in the record, and we're going to sustain the objection.
Thank you. I don't have any further questions on accounting. I don't know if my co-counsel has questions for engineering.
I do. I'll be brief.
Okay.
Mr. Franklin, is it true that Redbird witness Beckmeyer indicated there continues to be title deficiencies?
You'll have to speak up.
Has Redbird indicated that there are title deficiencies that have continued?
Yes, that's correct.
And is it true that past commission orders have allowed up to a certain amount for closing costs?
Yes.
Nothing further from me, Commissioner. All set.
All right, then. There are a few commission questions. So I will go ahead and visit those at this time. Is there any precedent for the commission granting approval of a transfer where rate base was not set?
Not to my knowledge.
All right. Is there any precedent for the commission granting approval of a transfer while due diligence costs are not set?
Again, not to my knowledge.
Is there any precedent for the commission granting approval of a transfer where the amount of an acquisition adjustment is not set?
Not to my knowledge.
Do you agree with the company that recent changes to North Carolina General Statute 62-111 change the way the commission should decide these cases?
Absolutely not.
And could you explain your thoughts and observations as it relates to that?
Yes, sir. So the session law provides that the commission shall issue the order approving the application upon finding that the proposed grant or transfer, among other things, is in the public interest. And this is in my testimony, by the way, on page 21. And the public staff does not believe that the commission can determine if a transfer is in the public interest if it does not know the impact of to a rate base and customer rates of the acquiring utilities proposed acquisition adjustment and due diligence expenses.
All right. How does the public staff respond to Redbird's argument that Etowah is distressed due to its, number one, repeated violations, number two, lack of profitability needed to secure the capital required to address the issues causing the violations, or number three, invest capital to improve its plant assets?
So if you look at the definition of a troubled system in docket W-1000 sub 5, and that order approving transfer and denying acquisition adjustment that was issued January 6, 2020, it determines that a system is operationally troubled if it has various system deficiencies, ongoing environmental regulatory violations, and frequent customer complaints. The Public Staff Consumer Services Division received 0 customer complaints over the 3-year period that I requested information on. As far as ongoing environmental regulations, there are some and some that are recent. But again, when you look at the determination of the frequency, it does not meet, to my opinion, as ongoing. They are occasional. The call form violation that Mr. Cox mentioned was actually, there was one in 2021 and another in 2023, about 17 months apart. And there have been some BOD violations, and then with the collection system, there's been a sanitary system overflow. So I don't consider that to be ongoing. There has been some, but not ongoing. And then various system deficiencies, again, supported by the infrequency of violations, the lack of consumer complaints, and my site visit, although it was a 1-day visit, and even the report of McGill did not identify, I would call, various system deficiencies.
Okay. Can you explain how the changes to Etowah's calculated rate base as of December 31, 20, I believe this should be 2022, were caused by the reduction of depreciable lives from where they were set in the last rate case?
I'm sorry, Commissioner McKissick, could you repeat that?
Yes. And one thing, I believe there may be a date here that was provided in this question that might be in error. Excuse me, give me 1 second
Okay.
to clarify that detail. Standard 2023. All right. Well, let me re-ask that question with, it looks like the date was correct. It was in commission's questions. Explain how the changes to Etowah's calculated rate base as of December 31, 2023 were caused by the reduction of depreciable lives from where they were set in the last rate case.
The lives that, if I understand your question correctly, and in my testimony, I discussed the adjustments I made, but the lives were,
What I'm trying to get is, would there be a difference between the rate base as proposed by the public staff in its testimony and the rate base calculated using the depreciable lives established by the commission in the last rate case?
no, because we use those lives for the items that were similar in the additions that have been made since the last rate case. The only ones we changed were the ones that were not covered in the previous rate cases.
Thank you.
Mhm.
Does the public staff disagree with the company's position that the relevant rates for purpose of evaluating whether the transfer is in the public interest are those that will be in effect post-closing?
No.
All right. Does the commission have the authority to set rates in the next general rate case regardless of whether future rate impacts upon Redbird's ownership are evaluated in this proceeding?
Yes.
Would the commission's ability to allow or disallow due diligence cost in or recovery of an acquisition premium be diminished if the rates were deferred to a rate case proceeding as the company requests?
I would not say, what I would say is since Redbird is proposing to go to uniform rates, that adding the additional information for an acquisition adjustment and due diligence at that time with the additional cases that would be required to be combined into a uniform rate and the time restraint that we're under with a rate case, that it would be overly cumbersome and difficult and for no reason when they have the information now.
All right, given that the company is not asking us to rule on these issues, why do they need to be taken up in this proceeding?
Because back to, for the commission to make a decision whether the transfer is in the public interest, they need to know this information and understand what the impact to rates is prior to them purchasing the system versus afterwards.
May I also add some supplemental comments regarding the acquisition adjustment? From the accounting perspective, we need this information to be determined now because on the company's books, as soon as the transaction is closed, if the transaction closed, the company need to record on their books the purchase acquisition adjustment and start amortizing the purchase acquisition adjustment from there. In order to amortize that, we need to determine the depreciation life for the PAA.
Would it be the public staff's position that calculation of an acquisition adjustment, your calculation begins amortization as of the date of the contract? Is that correct?
As of January 1st, 2024.
January 1st, 2020.
Yes.
All right. And has it been the commission's past practice to begin amortization of the acquisition adjustment before consummation of the acquisition in cases in which an acquisition adjustment is ultimately allowed?
I don't know either way.
Okay. I think that covers the commission questions. Let me look to my colleagues here to see if there are further questions they may have. Yes, Commissioner Hughes.
Sure. Weigh in on this, but the testimony of that, the precedent was then to set the rate base and deal with diligence. Was there any discussion with the company when, I mean, there was two of you, but when you went to customer notice about including something related to acquisition adjustments or due diligence in the customer notice? I have the customer notice here in front of me.
Yeah.
It talks about the investment capital would lead to a rate increase, but for customer, there's no.
Yeah, so we used to include that information, Commissioner Hughes, in these notice to customers for Redbird. But when we were doing the Bay Tree notice to customers, the company filed a motion objecting to having that information in the notice to customers, and the commission agreed. So so it was not included in Bay Tree, and so Etowah was the next one. And so we assumed that if the commission didn't want it for Bay Tree, they wouldn't want it going forward. And so the Etowah did not include that information for that reason. I hate to say that, but I will also say that the 7 additional statements that we've received that were before the public hearing, but they were after my testimony was filed, and one actually refers to my testimony directly. So I think, I don't have full proof, but that part of the reason why we received these so late is they saw my testimony, which has those impacts in it.
Any further questions, Commissioners? And your testimony is consistent with my recollections as well about the notice. All right, if there are questions on Commissioner questions?
Nothing further.
Nothing further from staff.
All right, in which case we will return to the applicant for your rebuttal.
Thank you, Commissioner McKissick. At this time, I would call Josiah Cox, Brent Teese, and Jim Beckemeyer to the stand as a panel on rebuttal.
And Mr. Cox, you're still under oath. So we'll just have the other two gentlemen put the left hand on the Bible, raise your right hand. Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you.
Commissioner, just as a procedure, at this time, the public staff would like to move their exhibits into evidence.
Go right ahead.
Okay, sorry.
I thought we already put the testimony into evidence from the very outset. So I don't think there were any other exhibits that I'm aware of that I recall. Now, I stand to be corrected. But we did get the testimony, including Hitton's testimony, into the record. All right, well, if you want to make a motion about the pre-filed exhibits going into the record, that'll be fine. We will.
Yes, we like to move the exhibits of Lynn Fiesel that were included with her pre-filed testimony. I believe there were exhibits 1 through 4. Move them into evidence, get them into evidence.
All right. Motions has been made to admit those documents into evidence. Without objection, your motion is allowed. And we'll proceed with the testimony of the rebuttal testimony of the applicant.
I'm sorry, do they need to be sworn in? Oh, sorry.
They were sworn in, yeah. We're
All
okay.
right, forgive me.
So you must tell the truth.
Mr. Cox, I will start with you. Walk through similar questions. Mr. Cox, can you please state your name and business address for the record?
Josiah Cox, 1630 DePere Road, Suite 140, St. Louis, Missouri, 63131. And I'm the president of Redbird and CSWR LLC.
Okay, well, you just answered my next question. Mr. Cox, on November 13th, 2023, did you cause to be pre-filed in this docket rebuttal testimony consisting of 28 pages and 2 exhibits?
I did.
And do you have any corrections to your pre-filed rebuttal testimony?
I do not.
And if I were to ask you the same questions that are in your rebuttal testimony while you are here today under oath, would your answers be the same?
Yes.
Thank you. And Mr. Teese, can you please state your name and business address for the record?
My name is Brent Teese. Business address is 1630 DePere Road, Suite 140, DePere, Missouri, 63131.
And by whom are you employed and in what capacity?
I'm the Vice President Corporate Controller for CSWR LLC and its affiliates, including Redbird.
And Mr. Teese, on November 13th, 2023, did you cause to be pre-filed in this docket rebuttal testimony consisting of 10 pages and 1 exhibit?
I did.
And on November 15th, 2023, did you cause to be pre-filed corrected, confidential, and non-confidential rebuttal testimony consisting of 10 pages and 1 exhibit?
I did.
And do you have any corrections that you need to make to your pre-filed corrected confidential and non-confidential rebuttal testimony?
I do. On page 5, I'm sorry, it would be page 6 of the corrected filing. It does say page 5 at the bottom. However, it is page 5 and the chart that begins on line 10. The line in that chart labeled accumulated depreciation, but it's DEPR is what's used for depreciation. The number that is in the testimony says it's a negative number, 1,301,696. That should be a negative number, 1,304,796. And since that table results in a sum for rate base, when you go down to the bottom line in that table that's labeled rate base, the total in the file testimony says 426,661. The corrected value is 423,561.
Thank you. And noting that correction, if I were to ask you the same questions that are set forth in your corrected testimony while you're under oath here today, would your answers be the same?
Yes.
And finally, Mr. Beckemeyer, can you please state your name and business address for the record?
James Beckemeyer. My business address is 13421 Manchester Road, St. Louis, Missouri, 63131.
And by whom are you employed and in what capacity?
Beckemeyer Lemoyne, I'm a member.
And on November 13th, 2023, did you cause to be pre-filed in this docket rebuttal testimony consisting of 12 pages?
Yes.
And are there any corrections you need to make to your pre-filed rebuttal testimony?
No, they're not.
And if I were to ask you the same questions today under oath, would your answers be the same?
Yes, they would.
Thank you. Commissioner McKissick, at this time, I would request that the pre-filed rebuttal testimonies of Mr. Cox, Teese, and Beckemeyer be entered into the record as if given orally here today, and that Mr. Cox's exhibits designated as Cox Rebuttal Exhibits 1 and 2, and Mr. Teese's rebuttal exhibit number 1 be identified as marked when pre-filed. And Commissioner McKissick, I don't know if at this time you want me to request to move those exhibits into evidence.
I think it's just appropriate to go ahead and do it now.
Okay,
Mhm.
thank you. So I'd like to move to have those exhibits entered into evidence.
Excellent. The motion which you have made to introduce the rebuttal testimony of Mr. Cox, consisting of 28 pages, as well as 2 exhibits, Mr. Theis, as amended from his testimony, consisting of 10 pages, with 1 exhibit, and Mr. Beckmeister, consisting of 12 pages, will be admitted into evidence and treated as if given orally from the witness stand. The attached exhibits to the pre-file rebuttal testimony will be identified as it was marked when pre-file, and the exhibits relating to the testimonies which have been identified here and above will be admitted into evidence at this time as well.
Thank you. And
Absolutely.
at this time, the panel is available for cross-examination and questions from the commission.
Mr. Cox, I'll start with you. So starting on page 3 of your rebuttal testimony, you describe the basis of public staff witness Franklin's assessment of the Etowah wastewater system and your disagreement with that assessment. Will you please read for the commission the sentence starting with given on page 4, line 3?
Given Mr. Frank's lack of experience with wastewater utilities, I question whether he is qualified to accurately or adequately assess the current condition of Etowah's facilities, their functionality, or the upgrades or improvements the wastewater system will require in the future.
And are you familiar with North Carolina General Statute, Chapter 6215?
No.
And can I read to you subsection B, which states in pertinent part, and I quote, "The public staff shall consist of the executive director and such other professional, administrative, technical, and clerical personnel as may be necessary in order for the public staff to represent the using and consuming public." And subsection D, which I'm going to paraphrase for you, states that the public staff's duties and responsibilities include to review, investigate, and make appropriate recommendations to the commission with respect to the reasonableness of rates and service furnished or proposed to be furnished, and intervene in transfer proceedings. Do you accept that subject to check?
Yes.
Is it your testimony that Mr. Franklin is not professional and technical personnel?
No, I just completely disagree with his findings.
And are you aware that Mr. Franklin has worked as a member of the public staff for over 4 years?
No,
Did you read his resume before making those comments?
I base my comments solely on the fact that sanitary sewer overflow and fecal coliform violations not being considered repeated violations, not being considered distressed.
So are you aware that Mr. Franklin has also testified in 3 prior Redbird transfer proceedings?
Yes,
And that he's also testified in numerous water and wastewater proceedings before this commission?
subject check, yes.
Subject to check, do you know if Mr. Franklin has ever filed incorrect testimony or testimony regarding the wrong system in any of the dockets he's testified?
I have no idea.
Subject to check, would you accept that he is not?
Sure.
And have you ever filed testimony regarding the wrong system in any of these dockets?
Yes,
And are you aware that it was our public staff engineer, Mr. Franklin, who noted that error and facilitated contacting your company?
you know, that really has nothing to do with whether or not these things are distressed, and the fact that fecal coliform violations are a public health risk and that BOD violations show that a plant is failing.
Objection, and also your testimony directly attacks his capabilities. So I would argue respectfully,
Objection, I would
Could you-
note,
Go ahead, state your basis for your
I would
objection.
note that all that is stated in the testimony is a lack of experience with wastewater utilities specifically, nothing more.
And could you restate your original question?
have you filed incorrect testimony regarding systems in these dockets?
Not in this docket.
Did you file incorrect testimony in the Bay Tree docket?
Yes,
Let
And
the record reflect, I will overrule the objection. Go ahead.
thank you, Commissioners. And do you still want to, I'll move on through this line of questioning. So on page 5, you contrast of your rebuttal testimony. You contrast the preliminary survey and analysis by McGill against the work of Mr. Franklin, correct?
correct.
In addition, you point to the preliminary survey and an analysis by McGill as support for Redbird's contention that Etowah's system is distressed and troubled, correct?
Correct.
Are you familiar with the joint application confidential attachment L?
If you can tell me what it refers to, I can say what I'm familiar.
It is the McGill Engineering Memoranda.
Yes,
And Commissioner, I'm going into a line of confidential questions.
All right, then we will go into confidential setting. If any witness that should not be in the hearing room when confidential testimony is about to be provided, they could leave at this time. Looking at the attorneys, it looks as if everybody who is here is entitled to be present and to hear and be a part of the testimony about to be given. And let the record reflect we're going in confidential testimony session at this time. witnesses.
So is it your contention that Mr. Franklin is unqualified based on the fact that you disagree with his conclusions in this case? Is that correct?
No, I disagree completely with his statement that this is not a distressed utility based on the violations and the severity of those violations.
You also indicated in your testimony that Mr. Franklin did not have experience in constructing or operating a wastewater system, correct?
Correct.
And if that's your contention, that not having that experience means that he cannot offer a qualified opinion on the condition of the system?
No, I just disagree with the severity of the violations and his opinion that's not distressed.
So if you disagree with him, even though his findings are consistent with the findings of the engineers that you hired, then your determination is that he is not qualified?
No. And my engineers did not say that these systems were not distressed. They gave visual inspection and component analysis on a piece by piece.
And sort of just a follow-up to this line of thinking, are any of the presiding commissioners, do any of them have experience in constructing or operating a wastewater system?
I don't know the answer to that question.
And if the answer is no, would you render the opinion that they're not qualified to make a decision in this case?
Absolutely not. They're utility regulators.
And Mr. Franklin is a utilities engineer.
And I disagree completely with his assessment of whether or not a system dumping human pathogens untreated into a stream is not distressed.
So if you can, read for the commission the paragraph starting with "in contrast" on page 5, line 12 of your testimony.
Oh. Could you point me again to where you would like me to read?
Page 5, line 12.
Line 12. In contrast, Mr. Franklin testified he visually inspected the Etowah facilities on one day. An accurate assessment of the condition where it typically requires not just visual inspection, but physical inspection, which can uncover structural issues and those that may be cosmetically hidden.
You were going really quickly. I wasn't sure if the. I understand we all want to get this over with, but just slow down a bit. Have you personally completed a physical inspection of the Etowah wastewater system?
No, I've not been to Etowah.
Okay. And has McGill completed a physical inspection of the Etowah wastewater system?
Yes, they have.
Okay, and Commissioner, at this time, I would like to introduce a cross-examination exhibit. It is the response to public staff data request number 14.
Here we start.
And Commissioner, if I can ask to have it marked as Public Staff Cox Rebuttal Cross-Examination Exhibit 1.
Duly noted. It will be. We should have this marked as a rebuttal panel exhibit since they're up as a panel. Just for the record, okay? And it will be your rebuttal exhibit number 1.
No objections.
And Mr. Cox, did you prepare these responses?
I've reviewed the responses, yes.
Okay. And can you take a look at the response to question number 2, subpart A on page 3?
I do.
So you indicated in the affirmative, yes, that you did not, whether Redbird or its contractors have conducted a physical inspection, correct?
Yeah, yes, correct.
And specifically, McGill performed a site assessment that was a physical inspection, correct?
I believe that's correct.
And then if I could turn to confidential attachment L, we don't need to actually discuss the confidential material. But if you turn to page 23, pre-file direct testimony,
My pre-filed direct
your
testimony.
pre-file direct testimony.
Pre-filed direct testimony.
Mhm.
Okay, I have it.
Okay, and then can you turn to page 23 and
Got it.
read lines 6 through 11?
McGill's survey of the Etowah was based on data provided by the seller.
Just slow it down a little.
McGill's survey of the Etowah system was based on data provided by the seller, information available from public records, and information gathered during a field survey of visible above-ground assets. McGill's field survey did not include detailed investigation of system components or any system testing procedures, or inspection or assessment of the pipelines, valves, or other below-ground facilities.
Is it your testimony that Redbird or its contractors, such as McGill, conducted a physical inspection of the Etowah wastewater treatment plant?
Yes, in fact, we've shot in manholes and depths of lines and all that kind of stuff as part of our GIS survey.
Sure. And what is the difference between McGill's preliminary survey and the survey and analysis, and Mr. Franklin's assessment?
I would say be popping manholes, going into lift stations, all that kind of good stuff.
But they conducted a visual inspection as well.
Who?
McGill.
Correct.
And McGill and public staff witness Franklin both conducted visual inspections.
Correct. They both conducted visual inspections in addition to the physical inspection.
Now, on page 6 of your rebuttal testimony, you also suggest that Mr. Franklin has dismissed NOVs as having no consequence. Is that an accurate representation?
Can you report me to where you're referring to?
Actually, before I get to that, when was, I'm backtracking a little bit. When was the physical inspection conducted?
It's been ongoing. They have to survey all the lines as part of the GIS mapping.
By McGill.
McGill has done a lot of that survey work, correct?
So do you consider the survey work a part of the physical inspection?
It is a physical inspection of the lines. They have to shoot them in, literally have to put in a laser to get the depth.
So going back to page 6 of your rebuttal testimony, you have that pulled up?
I do.
So you suggested that Mr. Franklin has dismissed NOVs as having no consequence. Is that an accurate representation?
Where my testimony you're referring to? Just what line? I apologize, I don't see it.
Oh, I'm sorry, I'm pulling up your testimony on my computer. Line 3.
Line 3. I have January 9th, 2023, sanitary sewer overflow event.
Starting with however.
However, yeah, okay. Should be concerned, okay. I see.
Okay. So was my statement an accurate representation of your testimony?
I'd say very clear, I think the public staff and commission should be concerned and should not disregard the potential for these type of violations to reoccur in the future if the acquisition is not approved.
So is West Elm Hills Utility Operating Company a predecessor of Confluence Rivers Utility Operating Company, Inc.?
No,
Was West Elm Hills merged under the Confluence Rivers name?
no,
Is Confluence Rivers Utility Operating Company a subsidiary of CSWR LLC?
yes,
And subject to check, did Elm Hills close on the acquisition of the Berkshire Glen utility assets on June 30th, 2020?
we own Berkshire Glen. I don't remember who closed on that.
Okay. So point being, you own Berkshire Glen.
Correct.
Okay. And has Berkshire Glen been in a state of non-compliance for 12 of the last 12 quarters?
No, in fact, the ECHO database, if there's a statement on their database that says there are 4 states in the country that the testing results are not linked to the ECHO database, so none of the ECHO compliance data is correct.
So I'm gonna just bring your attention to page 6 of the discovery response in discovery response 14.
Can you, which day request were you on?
Basically all of it. Do you mean that section? I'm data
Yeah,
request
which,
14.
14, correct.
Yeah.
All right, I see it.
Section C sort of runs through, and I will, in the interest of time, I won't read all of the paragraphs. It is in the record for the commission to review. But wouldn't you say that your response to this DR request dismisses the seriousness of the Confluence Rivers non-compliance, exceedances, and violations at Berkshire Glen?
No, because the EPA database is not correct.
Now, starting on page 8, well, I have a backtrack. Is good standing the same as an effluent that meets the permit limits?
I don't know what good standing is unless it's inside an environmental compliance agreement.
Starting on page 8, you discuss the viability of utilities from your experience with Redbird's affiliate, Cactus State Utility Operating Company, which is regulated by the Arizona Corporation Commission, correct?
Which part of my testimony you're in?
Page 8,
Of my rebuttal?
yes.
Sorry. Thank you. Okay, have it.
So on page 8 of your rebuttal testimony, you discuss the viability of utilities from your experience with Redbird's affiliate, Cactus State Utility Operating Company, which is regulated by the Arizona Corporation Commission, correct?
Correct.
On November 3rd of this year, Cactus State provided notice that Cactus State's counsel would appear in person at the Arizona Corporation Commission hearing scheduled to begin on November 8th, and that Cactus State's witness, Josiah Cox, would appear via WebEx. Did you testify via WebEx in the hearing on November 8th? The ACC hearing?
I mean, I testified recently in the ACC hearing. I can't remember which day it was.
And was that via WebEx?
Yes.
Okay. And did Caitlin O'Reilly testify in the ACC hearing on November 8th?
I do not believe so.
Did Caitlin O'Reilly attend this commission's hearing on November 8th? in the Bay Tree matter.
Objection, I'm not following the relevance of this line of questioning.
If you could provide some context where you're going so that we can,
Goes directly to the credibility of the witness, because this witness, it is sort of what I'm trying to elicit through this line of questioning, has falsely presented information to the commission. And if they're willing to do that in other dockets, I would contend that we cannot rely on the information that is testified to here.
I'm unclear about what false testimony this witness has provided.
False information.
Or, again, I'm unclear about what false information has been provided.
oh, I'm going to give you a little leeway here, but try to get to the point very quickly.
Sure.
I'm going to overrule the objection at this time, but that's a short leash.
So did Redbird or Cactus State request or attempt to provide substitute witnesses in either the Arizona or North Carolina hearings scheduled for and held on November 8th?
I don't remember. And I don't remember when those hearings were held. Sorry, don't remember.
2 weeks ago on November 8th. But I guess, and I'll quickly wrap up this line of testimony, Commissioner. But did Redbird convey to the commission that they were unable to be here for that hearing because they were testifying a hearing in Arizona?
I don't remember scheduling conflicts.
Well, if there were no scheduling conflicts, why weren't you here?
I literally don't, I have no idea what you're talking about.
Okay. All right, moving on.
Yeah, why don't you go ahead and move on? I'm aware of what you're talking about. So it's duly noted as a part of the record.
Thank you. So starting on page 3, line 13 of his rebuttal testimony, witness Beckemeyer testifies about why Redbird conducts due diligence and the contended benefits of such activities. Does due diligence benefit the company? If yes, provide examples. If no, provide an example. Why not? Do you agree? I'm sorry. I'm conflating the DR response with the testimony. So witness Beckemeyer's testimony was that Redbird conducts due diligence and the contended benefits of such activities. And if you, at this time, Commissioner, I'm going to ask that public staff data request number 13 be marked as rebuttal panel exhibit 2.
Now, in terms of confidential information, have you concluded everything that needs to have been addressed? No? Okay. Guess one of them. You again. This will be rebuttal cross exhibit 2 for this panel.
So the question states, does due diligence benefit the company? If yes, provide examples. And the response was, yes, it does. So do you agree with Mr. Beckmeyer's response to public staff data request number 13, question 1B, that due diligence benefits the company?
Were you asking me this question?
Yes.
Okay, I'm sorry. I thought you were talking to Mr. Beckmeyer. So I apologize. I thought you were talking to him, so I totally missed that. Could you just ask me that one more time, ma'am?
Do you agree with his response or not?
His response about what?
To question 13, number 13, DR 13, question 1B. Does due diligence benefit the company? If yes, provide examples.
So you asked me, does due diligence benefit the company? Yes.
But it's nevertheless your position that the customers should absorb those costs?
Yes, because they tell us what kind of improvements the plants need to have, whether we have legal access to the various components of the utility. You know, do we have to get more legal access? Do we have to cure real property issues? For sure.
Do you agree also with Mr. Beckmeyer's response to public staff data request number 13, question 1A, that the primary benefit to conducting extensive due diligence prior to closing an acquisition is to identify any defects in the system assets in order to plan for the capital improvements that will be needed to properly operate the system?
Yes.
However, in your rebuttal testimony, page 18, lines 1 to 7, you state that the results of McGill's projection of capital improvements is preliminary, and that Redbird has found that the true condition and needs of acquired systems can only be determined after Redbird owns and operates those systems. Can you then explain how the preliminary cost estimates developed by McGill benefited the Etowah customers?
Yeah, absolutely. They outline all the improvements that are necessary to do right now. I mean, when we talk about BOD violations or ammonia violations, that means you have insufficient air. The extended air plant is not designed to be able to treat those components on a consistent basis. Maybe it points to failing components. When we own a system, I've seen crazy stuff. There's a part of the system that wasn't mapped, that didn't exist. There's a manhole buried in the woods that's bringing water in. So we can't know what we don't know until we own the system. And historically, these owners, as evidenced by having a sanitary sewer overflow for 2 weeks that went unreported, we don't know what else they're not reporting.
Did the company significantly reduce the planned improvements at Bearden?
Sorry, I don't recall Bearden right now.
I'll move on. So I'm going back to DR response, I'm sorry, DR 14. And on page 6, the response to question 6.
DR 14, what page?
Sorry, DR 13,
13.
6C.
I see it.
So the public staff asked for a list of transactions closed by CSWR affiliates, including state, regulator, name of the system, closing time frame, start date, end date, amount of due diligence costs incurred, and amount of due diligence costs allowed for recovery in rates. And your response to 6C is that Redbird objects to this request to the extent it requires the company to undertake legal analysis, research, and/or compilation of new studies. You've testified here.
I'm sorry, I'm going to object. The response actually goes on and says more than what you just quoted.
Commissioner, I'm happy to read the entire thing.
Why don't you read the entirety of it, please, for the record and for accuracy, so nothing's out of context.
Redbird also objects to this request on the basis that it is unduly burdensome, as this data cannot be easily queried from our systems to provide a comprehensive response in the given time frame. Subject to and notwithstanding these objections, Redbird will provide a list of all acquisition cases by state and docket number. Was that the response?
Yes.
So we requested information regarding due diligence expenses. And when I say we, meaning the public staff and other jurisdictions, but you objected.
Again, objection. The response included objections, and then it also included a response that we would provide a list of all of the dockets with the docket number.
I'm going to say,
Commissioner, if I may,
okay,
the company has testified in this proceeding that no state has disallowed their due diligence expenses, and they provided no documentation or support for that position. And the public staff did ask for that information. So we're expected to rely on, respectfully, simply their word with no supporting documentation.
May I respond?
yes.
So we did respond. We said we would provide the docket numbers. I would also note that we had 3 days to respond to these requests. And so as our response indicates, given the amount of time, we did not have the amount of time to compile all of the specific information that was requested. And so given the amount of time, we thought we provided an adequate response. Nor did we hear anything further.
Were there any further communications
Um,
that you're aware of?
My only contention is not necessarily with the DR response in itself. It's that we cannot rely simply on the testimony presented here today in that regard.
Commissioner McKissick, I'll answer your question. No, there were no additional follow-up requests.
And is that information that could be provided in a late file exhibit?
Subject to speaking with Redbird representatives, I would have to look to them.
Do you mind if I respond to that? I mean, it would be very difficult to curate that information because it's not tracked in the way that they're requesting. And the amount of time that it would take would be overly burdensome and incredibly expensive.
Yeah. Can I add one more to that as well? Yeah, we roll this stuff into rate base. So it becomes part of our plant and service. And, once it goes through a rate case. So that's how we track it, is all it gets capitalized in rate base. So I'd be glad to share rate cases where it's capitalized.
So that could be provided.
Yes, we could provide evidence of rate cases where these costs have been capitalized.
Would that satisfy the query made by the public staff, or what additional information would you want to see provided in a late filed exhibit?
So Commissioner, my only response to that will be the burden of proof is on the applicant. So I will leave it up to them to determine whether or not they'd like to meet that burden.
And again, Commissioner McKissick, we're not seeking a ruling on, the amount of due diligence costs that are appropriate. We're here today before our application, our transfer application.
There were certainly short periods of time that were provided for in this discovery schedule, that's for certain. So I mean, there would be challenges to pull information together. However, I understand fully the public staff's concern that they don't believe that they received full and complete information that was responsive to the request as it was stated. I'm going to go ahead and overrule the objection at this time, but at the same time, I want to allow the applicant an opportunity to submit a light filed exhibit that can satisfy as fully as possible what they're able to provide in terms of informational content at this time, based upon what has been requested.
Thank you, Commissioner. Starting on page 21, line 21, you testify of your rebuttal testimony. I'm sorry. You testify, and I quote, "Therefore, it serves no purpose for the commission to consider hypothetical future rate impacts in this case." Is your testimony that an acquisition adjustment and due diligence cost directly related to the transfer application?
I'm sorry, could you say that question again?
I'll rephrase. I'll ask another question. Are estimated rate impacts a method of quantifying the costs of a transfer?
Or estimated rate impacts? Their estimates, correct?
No. Are they a method of quantifying the costs of a transfer?
Yeah, so for example, when the financial witness was up here earlier, she talked about previous rate cases and annual reports being sources of truth that we could rely on. And for example, the last rate case that I went through was actually a rate case on a margin of expenses. It wasn't a rate-based rate case. So it really wasn't very helpful for determination of rate base. In addition to that, there's a disagreement between, how the tap-on fees were calculated. Were those revenue, which was shown in the annual report, but now you're including with SEAC, which was never included in the annual report. So none of those are really known. And that's why I just have a problem with estimates and why we talk about you really can't know what the effects of these are until after we've owned it and gone through all the information and can present some future rate hearing.
And are you aware that this commission earlier this year stated in its order in docket number W-354 sub 398 on page 24, I quote, to assess whether granting or denying an application is in the public interest, the commission considers both the costs and the benefits to customers of the acquiring utility as well as a system to be acquired.
Where's that my testimony?
No, I'm referring you to the commission's order.
Okay. In what here?
I'm sorry, what order are you referring to?
Docket 354 sub 398, page 24.
And again, what docket is that? What matter?
If you could be
I'm-
precise and clear in terms of what proceeding that is relating to, and
Yeah, and I would also request that if you're going to be asking questions
It
about the order.
relates to Carteret County. And my only point, Commissioner, is that we are citing an example of previous cases where the commission has made determinations about what considerations are important in making its assessment.
And
What it considers when it makes its assessment.
And if you're going to ask the witness questions about a particular order, I would just request that he be given a copy of the order so that he can refer to it.
I think that's a reasonable request. So if you'd like to provide the witness a copy of that order, so the witness can respond fully and completely and competently to the extent he has the ability to do so.
Commissioner, I'll move on. I'll just ask a general question. Has the commission, to your knowledge, considered rate impact to determine public interest?
Historically, yes.
And that was all done. I'll turn it over to my colleague for this witness.
Where are we in there? Oh. All right, I believe most of my questions will be directed towards Mr. Forgive me for your last name, Tees.
Tease.
Tees.
The H is silent.
Tees, I need Tees here. Thank you. Regarding net book value, what is Redbird's position on what should be included in calculating net book value?
Ms. Feasel talked about what consists of rate base. And so those would certainly be components: utility plant and service, accumulated depreciation, SEAC, and then there's some lesser components, cash working capital, and those types of things. And did you ask for, you didn't ask for rate base, you asked for
Net book value.
Yeah, and so then I think net book value, if you think historic net book value kind of stops there. And then if you think about an acquisition adjustment approved or not, that would also be on the books clearly. So that'd be part of the value of the system should it be approved.
Okay. And talking about purchase acquisition adjustment, when determining whether the purchase price is reasonable, did Redbird review, I know two options, Etowah's annual report and or the last rate case as a reference for net plant value?
Those evaluations are not done by me, but I know that we have access to the annual reports. I'm not sure about the prior rate cases.
Do you know if anyone looked at the prior rate case in this docket before agreeing to a purchase price?
I do not know the answer to that.
Do you know who would know the answers to that?
Mr. Cox may have some insight. I'm not sure he would know either.
Mr. Cox, do you know if anyone looked at the prior rate case before agreeing to a purchase price?
No, that was not, because our business developers,
So that's a no?
that's a no, correct.
Okay. What about annual reports? Did any of you look at the annual reports of Etowah before agreeing to a purchase price?
Yes, they looked at annual reports,
Okay, which annual reports?
the last 5 years, I believe.
Commissioner McKissick, I'd like to introduce an exhibit, because it will be rebuttal panel exhibit 3. The label on the exhibit doesn't quite match what I just described as the rebuttal panel exhibit, but it's oh. And commissioners, this is it's a summary exhibit of the data from annual reports. I would say subject to check from the panel and anyone else, that was produced by public staff.
That was produced by public staff, you said?
Yes, the public staff accounting office made this, pull the data from the annual reports. Rather than produce all the stack of annual reports for us to go through, we thought this would be easier.
So it was a compilation.
Yes.
Okay. Let's give McGrath a chance to review it.
Commissioner McKissick, I mean, I do have some concerns in that, I mean, if this is the public staff's data, I'm not sure how we're supposed to verify the accuracy or testify to whether or not it's accurate or not.
Well, they just testified that they reviewed the last 5 years. So if we want to just limit the questions the last 5 years, then that's fine. But it's,
I'm going to sustain that objection. I mean, if you want to limit the testimony of the last 5 years, I think that's fine, but this is not an original document. It is a compilation that's been prepared.
okay.
Now, I mean, let me ask you this, Ms. McGrath, do you have any problems if there were limitations on this testimony provided to just the 5 years with this document being used? I suspect you would continue to have the same objections, but I will look to you.
I would, Commissioner McKissick, because again, I mean, there's just no way to verify this data and we,
Well, that's the whole point of subject to check.
not on public staff compilations of,
I'm going to sustain the
thank
objection.
you.
Okay. But I still intend to ask this
You
questions.
feel free to ask the questions. We just won't be able to rely on this exhibit for that purpose.
All right. And to the whole panel, and just to revisit, did the three of you review the last 5 years of annual reports on Etowah? Or
I did.
Mr. Cox, did you?
No, not prior to signing the contract.
Okay. Mr. Tees?
Not prior to signing the contract.
So I guess my questions will be focused on you, Mr. Forgive me,
Beckemeyer.
Beckemeyer. All right. So in reviewing the annual reports, did you review them for any errors?
No.
Would you know if there were any errors in the reports?
No,
Did you compare, well, what data in the reports did you look at?
we would have looked at financial information, but quite frankly, we don't put much weight on annual reports for most of the sellers of utilities that we look at because they don't tend to turn out to be as accurate as you would hope once the acquisition is actually closed.
Since we have not had a break in a couple of hours, I'm going to go ahead and provide a 10-minute break at this time or recess. We'll come back on the record at approximately 6:08. Okay? And public staff, you're able to continue with your testimony, eliciting your testimony.
Thank you. I believe, Mr. Beckenmeyer, where we left off, we were talking about the annual reports that you reviewed. I believe your testimony, if I recall correctly, was that you didn't think the annual reports were very reliable. Is that correct?
That's a general rule. I'm not speaking specifically to Etowah.
Okay. But you did review Etowah's annual reports.
Yes, we review all annual reports as part of the purchase agreement process.
What were you reviewing them for? Like, what were you looking for?
We look for information related to what properties they reference to see what type of due diligence might be necessary for the deal, how many tracts of land might be referenced in a report. We definitely do look at it from some of the financial representations just to get an idea of certain financial considerations, but we don't put much weight in what those numbers are on the report.
Okay. Did you look at the 2022 annual report of Etowah?
My recollection, I think our standard processes would get the last 4 to 5 years of reports. So I can't say specifically, but I believe I did.
Right. Would you agree, subject to check, that the 2022 annual report from Etowah showed the net utility plant acquisition adjustment value of 193,518?
I don't recall.
All right. It was in response attached, Mr. Tees, this was your response to DR 15 included the 2022 copy of the annual report of Etowah. Do you have that in front of you?
I do not have the annual report for 2022 in front of me. No, I'm sorry.
I could bring a copy to you.
Wait a minute, I do.
Okay.
I apologize.
So I believe on page 5 of the annual report, that would be, I believe, line 6. What's the net utility plant acquisition adjustment?
There's no value on line 6.
Okay, sorry, line 7, total utility plant.
For the balance at the end of the year, which is the far right column, $193,518.
Okay. Did any of you, I think there's been mention already about the prior rate case for Etowah. Did any of the three of you look at that order from that rate case?
I did review the order. Yes.
Okay. Do you recall which sub number it was with the sub 9?
I do not. No, I looked at it recently looking for the tariff language, but I don't remember what sub it was.
Okay. Do you recall what the net plant value was in that order, or the net rate base?
No, well, let me take that back. I recall the net rate base being negative, but I don't remember any of the component values.
But you do recall the value being negative?
The total rate base, which would include utility plant service less CIAC or CIAC.
Was that information available prior to Redbird agreeing to the purchase price for Etowah?
I do not believe the 2022 report would have been. I think we heard earlier that the original purchase agreement was 2020. 2019, the original filing was in November 2020, and we would have a purchase agreement by that time.
But the order in the last rate case was available.
Correct.
How was the purchase price determined?
So our business developers always start with what they find in an annual report and say, hey, this is what we believe the purchase price should be, and it goes from there.
And by goes from there, generally speaking, what do you mean?
I mean, then the owner throws out a crazy number. It's worth $8 million. And we're like, there's no way in heck. And it goes back and forth and back and forth.
what due diligence does Redbird do to decide what's a reasonable price?
So review their annual reports, and then they create an asset list of everything that's inside the annual reports. That gets sent to an engineering team internally with, proposed line lengths and all that kind of stuff is how the due diligence is done. It's all a tabletop review with a business developer doing some photographs of their initial visit.
You have not provided that to the public staff, have you?
What?
The document you just described to support your determination of the purchase price?
No, because that's just an internal document. And then really, we make sure that, hey, there's enough assets here that we think from our best professional judgment would support that.
Earlier you testified, Mr. Cox, that the price that was settled on or agreed on was the lowest price that the seller was willing to take. Is that a correct representation of your testimony?
Yes.
Did you have to accept the seller's price?
No, we didn't have to. We didn't have to enter into the contract.
For the three of you, I'm not sure who would address this. How does purchase acquisition adjustment? Let's make sure we're on the same page with the same terminology. The purchase acquisition adjustment, essentially the price, the delta between the purchase price and net book value. Do we agree on that?
For North Carolina, yes.
Yeah, North Carolina. Okay. For accounting purposes, how is that purchase acquisition adjustment booked?
So there's an account specific to the NARUC Uniform System of Accounts. I believe it's 114 in the 1996 version, and it's held there until a commission rules on whether it can be included in rates, and then presumably at that time there's an amortization schedule. So yeah, it's subject to commission's review in terms of amortization and allowance in rate base, but it is held in that account.
Is a depreciation process required to start as soon as a transaction close? So prior to commission approval, but of that purchase acquisition adjustment?
Can you restate the question?
Sure. I'll rephrase it. When does Redbird have to start depreciation of the purchase acquisition adjustment?
It's an interesting concept there, right? Because if we did not have an amortization schedule or time frame or rate, if you will, approved by the commission, we could start on something and then have it change subject to a rate case. At the same time, if we didn't amortize it and the commission then inside a rate case said you should have started back here, you would just calculate what the value should be at that time. So it's a little bit irrelevant given that there's no commission ruling on what the depreciation or amortization rate is until a rate case.
I believe the Redbird's position is that I think you all refer to CIAC or CIAC.
Yes.
Should be included in the utility plant and service. Is that Redbird's position?
Yes. I mean, even in the North Carolina annual reports, the definition of CIAC includes or involves that it's an offset to assets in service. And even on, I know this document that you all passed out, it shows, and I confirmed in the annual reports that the value of the plant in service is significantly lower than the value of the CIAC, which points to some kind of accounting, technical, procedural problem where all the CIAC was not recorded as utility plant in service.
Can you identify any order of the commission finding that the utility plant and service associated with the CIAC tap-on fees are the same as the SEAC gross amount?
So can you restate the question?
Well, to rephrase, it seems a Redbird's position is that the SEAC should be included in UPIS, utility plant and services. That's correct.
I think by definition of what SEAC or CIAC is, it has to have an offsetting component in assets.
Can you identify any rate case that supports your position?
I think the uniform system of accounts supports that that's the way it's supposed to work. But I do not have a docket number in mind from the state of North Carolina that I know about how SEAC has been handled.
Commissioner McKissick, I'd like to introduce exhibit rebuttal panel exhibit cross exhibit 3. Find it now.
Rebuttal cross exhibit 3, which is about to be distributed.
It's the one that's.
Commissioner McKissick, so exhibit 3, you sustain the objection. So do we go to 4 or?
I did sustain the objection, so we would go to 4. That is correct.
Okay.
Thank you.
Thank you for duly noting that.
Well, I have to give Mr. Mehta credit. So.
Sure, thank you. Yeah.
So this, for the record, this exhibit 4 is Redbird's response to public staff's data request number 15. I have not included the exhibits that accompanied the response. Those exhibits, at least one of them, I know is confidential. So this is just the response. Do you have exhibit 4 in front of you, Mr.?
Let me make sure Ms. McGrath doesn't have any objections.
No objection.
No objections, you may proceed.
In question 1C, the public staff asked Redbird to identify the production where it provided detailed explanation of Redbird's amount for plant and service. In response, Redbird wrote, "No, the reference amounts are not included in any of Redbird's responses to public staff's data requests because Redbird had not received the most up-to-date financial information from the seller until shortly before filing rebuttal testimony." The question I have is, what updated financial data are you referring to?
So you're talking about on page 2, our response, letter C. You're talking about the reference amount not included staff data requests. I think, I don't know that there was any extra information that was specific to what we're talking about here, but we certainly did receive the 2022 annual report late, at least our team did. And that was our last bit of information that helped us kind of formulate the analysis of rate base. And so that obviously would have been in public staff's possession as well.
And that 2022 annual report that was filed April 17th, 2023.
I don't.
Subject to check, you agree?
Yes, it's back here buried somewhere, so I don't know for sure.
Commissioner McKissick, I'd like to go into a closed session to address one of the confidential exhibits that were attached to the response to DR-15.
Okay. We will now ask anybody in the hearing room that it's not allowed to be a party to present when testimony is provided related to confidential matters to leave the hearing room at this time. It looks as if everybody here is entitled to be present. if you will identify this particular exhibit, and it will be, and let us go into closed session to receive confidential testimony.
Sure. And I'm going to omit some of the questions I have prepared since DRs 13 and 14 are in the record, and I'll move to have those be marked as evidence
Okay.
shortly. But I did want to ask some brief follow-up questions. Were material defects identified for Etowah?
In what context?
So in your testimony on page 4, line 16 to 18, you testified that based on the foregoing activities, we determined that there are material defects in the title rights impacting Etowah that need to be cured prior to the closing or shortly thereafter.
Yes, there are title defects that were determined in the title review.
And in response to the public staff's data request, where we asked for a list of material defects. You go on to list them. I can read the entire response, but it's in the DR request, so I don't think there's a need to.
I think you're able to proceed
Okay.
unless I see objection.
No, I'm sorry. Can you just specify which response?
Response 2B,
Two.
where it lists the material defects.
Okay, thank you.
Sure. And did Redbird, well, how much due diligence costs were incurred in association with finding and resolving those defects?
How much due diligence costs? I
Mhm.
couldn't answer that question.
Okay. And did Redbird, well, do you have an estimate or approximation or anything?
I mean, how you determine due diligence or title defects is you have to look at the entirety of the title review of all the title documents in the relevant record. Then you have to have surveys performed on the tracts of land that are necessary, as well as we do surveys on the pump stations for this, like a more limited survey. And then you review everything in its totality to determine what the defects are. So from a title standpoint, you can't get to determining material defects until you've essentially done the first cumulative review of all the title work.
But you did identify the material defects here.
Yes, after we completed all the due diligence related to the title.
Okay. And do you have an estimate of what those costs
I
were?
couldn't tell you I mean, the attorney's fees are set forth. There's survey engineering fees. There's a lot of GIS mapping that goes into that as well, just to kind of determine where things are located. By way of example, the initial information that was provided from the seller led us to believe there were 10 tracts of land that needed to be purchased. And it turned out there were only 5. So we had to go through a process to ascertain that, to then limit it down to what actually was relevant to the operations of the system, and then do further title review on those 5 tracts, as well as all the easements, to come to that conclusion.
Sounds like a lot of work.
It is a lot of work.
So did Redbird seek a reduction in the purchase price for those costs?
Not at this time.
And then I'm gonna just bring your attention to your response to question 1D. Does due diligence inform the negotiation of the purchase price? And I will read your response in its entirety. Due diligence does not inform the company on the initial purchase price. However, in some instances, the discovery of material defects in the due diligence process has resulted in a reduction to the purchase price to accommodate the costs associated with curing the defects. This did not occur with respect to the Etowah transaction. Is that correct?
Yes, that's what was stated.
Nothing further from me.
So am I to conclude that the public staff is,
Yes, it does. Thank you.
okay. Just want to make sure.
I appreciate understanding. Thank you.
All right.
And at this time, Commissioner, I guess I would just like to make sure that we move all of our exhibits into evidence.
Right. We will move of course, we decided that our rule that in terms of rebuttal exhibit 3, that we sustained the objection to that, but we are admitting all of the other
1, 2,
exhibits into evidence.
1, 2, 4, and 5.
Yes. Any objection?
No objection.
Right. Without objection, they are admitted.
Commissioner McKissick, my colleague, is going to ask a few questions on
Sure.
redirect.
All right. That'll
Thank
be
you.
fine.
Thank you, Commissioner. I just have a couple questions for you, Mr. Teese. Can you tell me what types of information you need to know to calculate a rate impact?
Yeah, so the rate impact would be a future revenue requirement, right? That's ultimately how you would determine that. So in order to ultimately know that, lots of data needs to be known. Capital structure, returns, interest rate, in addition to the number of customers, whether consolidation is going to be going to happen among multiple systems, and how many connections are there. So there are a lot of details that you would need to know to kind of take one piece of data and estimate what the rate impact of that piece of that number would be.
And with respect to the Etowah system, do you have any of that information at this time?
No, I mean, other than being able to look at the books and estimate what the acquisition adjustment and due diligence costs would be for this particular transaction, we have none of the other information.
And all of that information will be part of a record in a rate case proceeding, isn't that correct?
That's correct.
And in your experience testifying in rate cases, is return on equity typically a controversial issue?
The most controversial almost every time.
Thank you. That's all I have.
Nothing further.
We do have a couple of questions from commission. So I'll go ahead and review those quickly, and we'll see if my colleagues also have some questions they'd like to have answered. Mr. Cox, you state on page 18 of your rebuttal testimony that appraisal work is included in the due diligence cost because it's necessary to determine fair value. Why is such work necessary in North Carolina where fair value only applies to sales by municipalities?
Maybe fair value is the wrong term there. Real estate value, because typically we've seen with owners like the owners of Etowah, they didn't include the real properties or the easement values in the original net book value.
I see. So you're not using that term fair value the way it is defined and utilized in the general statute of the state of North Carolina for those types of proceedings.
That is correct. Poor word choice. I apologize for that.
Okay. So I guess the next follow-up question was why should ratepayers reimburse the company for this expense? So I guess we can assume first you misclassified it or used the wrong terminology, but notwithstanding that fact, why should ratepayers reimburse you for these expenses or those expenses?
Yeah, I think our position is, Commissioner, that those land values and easement values were never included in rate base. So the customers have never paid for the benefit associated with those, and thus they're eligible for rate recovery.
Okay. And Mr. Theis, why should the commission reach back before its orders in W-933, sub-9, and sub-7 rate cases to add additional rate base from activities that happened prior to then?
Thank you for the question. I think, you know, when as I'm looking at this, I'm you know, suggesting that I think the books and records as they've come to today have some question marks and some inaccuracies. So certainly not suggesting the commission overturn precedent and those kinds of things. I'm simply looking at it from a sort of a fresh set of eyes going, this doesn't all add up, and then quantifying that. So again, I'm not suggesting that the commission changes previous rulings necessarily, but just looking at the financial analysis of it and wondering why it is the way it is and why it doesn't seem to add up to me.
Okay, very good. And Mr. Beckmeyer, if we look at witness Cox's testimony on page 19 of his rebuttal testimony, it addresses the remaining law firm costs included in due diligence that are in total from, I guess, Burns, Day, Presnell, who perform legal work required to secure commission approval of the proposed acquisition. Now, you state on page 11 of your rebuttal testimony that Burns, Day, Presnell provided the necessary legal services to assist Redbird in meeting its obligation to properly comply with the regulatory approval process. So I guess the question is, how do legal fees for filing and representing a client in a proceeding before the commission meet the definition of due diligence?
Meet the definition of due diligence? I mean, my definition of due diligence would be anything that occurs prior to real estate or small M&A transactions such as this to get the deal closed. And it is very common outside of the utility context, as well as I think within the utility context, that any permits or approvals that are necessary to get the deal done is part of due diligence costs.
And did the law firm of Burns, Day, and Presnell perform any title work for Redbird?
Not that mine, no, they did not.
They did not.
No. I mean, we did consult with them on some of the requirements to make sure we were clear what the public staff was requesting from a title standpoint, to make sure we had clarity of of how things would be presented, but they did not perform any title work in my knowledge.
Okay. And I believe in response to a question from a public staff attorney relating to these legal fees and due diligence costs, and the question was raised whether you intended to address the seller to see if there could be a change in the purchase price. And you indicated not at this time.
Correct.
Do you contemplate doing it subsequent to this hearing or at some later point in times so you can provide some clarity to that response?
Generally, how that would work is when we got to a point where there was clarity on what the closing requirements would be, that there would be a meeting internally with Central States and my team and others to determine if it was prudent to go back to the seller to seek a price reduction on certain defects that need to be cured. So that hasn't happened yet. It may happen on this transaction, but I can't say for certain if it will.
And if for some reason this transaction was not approved, is there a mechanism in the agreement, the sales contract, that would allow you to recover a portion of the due diligence costs that have been incurred in connection with this proceeding?
No, there's none. All the dollars spent in due diligence costs would be, if the deal is terminated, unless there was a breach by the seller, would be borne by the buyer and they have no legal remedy to go back to the seller to request reimbursement.
Thank you. I don't have any further questions that are here from commission side. Let me recognize my fellow commissioners. Commissioner Duffley.
I have a few. Good evening, gentlemen. I'm going to try to make these quick. So the first is for Mr. Thies. So Redbird takes the position you don't really have the financial information regarding plant and service until closing. But isn't it typical that access to invoices and other supporting information is provided during due diligence?
Yes, I mean, to the extent that we ask and, we're provided with some information, certainly there can be other information that comes from our actual operators and staff getting in there and seeing what the assets have actually had done to them. And so that's the information that's not there, is an actual running of the system and hands-on operation and understanding of what's actually been done up to the day of closing.
And so on page 5, of your testimony, your rebuttal testimony, you've updated that rate base number twice now. You updated it again today. What's the accuracy of that number, level of accuracy?
Of the rate base?
So I think it's updated to 423, or is that that's not confidential, correct?
No, it's not.
Yeah, 423,561. What's the level of accuracy of that number?
So I think that is accurate, but for the staff pointed out that there's possibility some accumulated depreciation is missing. So we would want to make sure that that's all included there.
Okay, so there's not any other information that you need other than that?
Right.
Okay, thank you. And so what other information do you need after closing?
Again, it comes to.
And I think, yes, you were on redirect. Was it your testimony on redirect? But go ahead, I interrupted.
Yeah, so I think, again, seeing what is there with the systems, and at times we will discover things that were on an asset list that aren't installed or vice versa, things that are there that we weren't provided information on. So then we go back and ask questions about, why do you have 3 pumps instead of the 2 that you told us about? And so it really takes owning and operating for us to feel like we actually have all the information about the assets that were there on the day that we took over.
And typically in your acquisitions, what's the percentage change once you're owning and operating versus pre-purchase?
Yeah, I mean, overall, and think, 200 plus acquisitions, it's not a huge percentage. The smaller the system, the greater the percentage probably. So in terms of, and it's smaller is not the right word, the more distress and question about historic accounting practices and those kinds of things, the more percentage we would get there. So I suspect something here. I wouldn't venture to gamble on what that percentage would be now, because obviously it's subject to check.
Okay, but what's your typical range?
I would say it's 5 to 10%.
Okay, thank you. So Witness Cox, believe you testified earlier today that Etowah's rates are set on the operating ratio method, and I just want to clarify for the record. Isn't it true that for small water companies like Etowah that the public staff recommends to the commission whether to use the rate-based method or the operating ratio method?
That sounds correct. And that's very typical from a system we would consider distressed, that they can't use rate base.
Okay. And let's move to that, the distress system. If you could turn to page 4 of your rebuttal testimony.
Yes, ma'am.
Okay, so I understand that your testimony is that the systems are failing. And I understand that it's because that the systems received 11 NOVs from September 1st of 2020 through October 1st of 2023. Is that accurate?
Yes, Commissioner. And then in addition to that, for the prior years, the 3 prior years, they had only 1/4 of compliance.
Okay, and do you know whether any of these NOVs resulted in further action, resulting in a civil penalty?
Yes, at least one resulted in a civil penalty. In addition to that, there's still a couple NOVs that are they're still open with DEQ.
Okay, and I think you may have received some questions, but for your current operating systems, Redbird operating systems, have they received any NOVs in North Carolina?
We've not had any notice of violation that were not covered in an agreement on consent or agreed order that have been sustained against us in the last 10 years.
Okay, can you explain that further?
Yeah, absolutely. So for example, I'll use Kentucky, for example. So in Kentucky, we get an agreed order. So that's agreement with the Division of Water. And the Division of Water says you have 24 months to do all the improvements necessary to bring these systems back into compliance. In that interim period, we do what I said earlier was triage work, where I think we're replacing motors and electrical components and all of that are failed. And then we're going through final engineering to get the final fixes, because most of these plants are not designed to treat waste to modern EPA requirements. So in that interim, the plant is still not treating for ammonia, for example, until final improvements are made. And that's covered inside that agreed order. But the Department of Water will issue us a notice of violation and say, but this notice of violation is subject to the agreed order.
And so you mentioned that's a procedure in Kentucky. Is it also a procedure in North Carolina?
It is. We've met DEQ with a similar proposal.
Okay, thank you. And do you know what the percentage of wastewater systems in the state of North Carolina has received NOVs between the same period of September 1st of 2020 through October 1st of 2023?
Sorry, I do not know the answer to that.
Okay, so how are you able to assess that 11 NOVs during that period of time is a failing system?
Because any NOV is a failure. And then when you have repeated failures of the same constituents, it shows the plant's not able to meet it. So for example, the BOD5 failures and ammonia failures that we've mentioned as part of this NOVs, right? What that really is telling everyone in the wastewater business, like, hey, this activated sludge plant is not really equipped to treat the waste down to the level that's required on a consistent basis.
So let's hypothetically assume that all of the wastewater treatment plants within North Carolina have received a similar amount of NOVs during this same period of time. Would you consider all of those wastewater systems failing?
Commissioner, I believe if that happened, the EPA would start to step in and put the DEQ into receivership, which has happened at least once in U.S. history.
Okay. So hypothetically, you would say yes, that all of those systems would be failing?
Yes, that'd be a very bad answer.
Okay, thank you. And then, with respect to, let me see, Mr. Thies, I'm going to go back to you just for one question. On page 9 of your rebuttal testimony. You refer to the depreciation neighborhood, it's lines 13 through 16. You talk about the depreciation practices for small water utilities and the amortization based on small water. So, and you guys, I'm just trying to get clarification of the record. I thought that I heard Mr. Cox state that once all of these, if all of the transfers go through and are consolidated, that you may not be a small water company or meet the requirements of a small water system. Is that accurate? And then what does that do with respect to this testimony?
Yes, I think there are a couple of thoughts there. One, economically, a small utility, and in other states, it's class A, B, C, or D. I'm not exactly sure what the levels are in North Carolina. It's often thought about to be revenue-based, but what we're dealing with are small isolated plants generally. And so when you think about depreciation, they sort of properly do fall under small water plant components and those kinds of things. I think the other note is that 50 years for collection and distribution lines is a pretty standard number, even for, larger systems, larger water utilities. So I'm referencing this because I know we're dealing with a very particular case, and this is a manual that NARUC put out specific to small water utilities, but it would not be significantly different for a larger utility over the same assets.
Okay, thank you. I have nothing further.
Commissioner Hughes, any questions? In light of the hour, I'm going to pass on additional questions that came to my mind. I don't think they're that enlightening and insightful that we would not be able to deem answers by reviewing the record. So that pretty much brings us to the conclusion of the hearing. First, I want to make sure that oh, yes. Questions on commissioner questions. I'm ready to bring it to a hearing. Yeah.
Public
I
staff.
apologize.
No questions.
No questions.
No questions from the company.
That was what I was assuming. So we're at the conclusion of the hearing. Of all exhibits been entered into the record that need to be entered into the record, is anybody aware of anything that has been omitted? If so, this is the time to get it officially into the record at this time. I'm seeing everybody nodding. Nobody's speaking, but I assume that means that there's nothing additional.
So I guess I'll make a general motion that any exhibits that were not previously entered be entered into the record at this time.
Without objection, your motion is allowed, even though it is probably redundant and unnecessary.
Yeah, totally fine.
All right. With that note, I believe there was one document with late file exhibit. That,
Yes, one late filed exhibit that we will be providing that is responsive to one of the data requests.
Excellent. If you get that in within 2 weeks of today's date, that would be excellent. If for some reason that 2 weeks does not look like it's feasible, then please get back with the commission staff and let us know what additional time would be necessary.
Yes, will do.
I would ask that proposed orders, any briefs of any issues you find appropriate to be filed within 21 days, the availability of a transcript, if that is acceptable. And on that note, that brings us to the conclusion of today's hearing. Let me thank you all for being here. Let me thank you for your endurance and tenacity and hanging in here to about 6:55 p.m. and 26 seconds. And I hope that you all have a very happy Thanksgiving.
Same to you, commissioners.
Thank you.
Thank you.
Bye-bye.